Okay, call the regular meeting of the Carmel-by-the-Sea Planning Commission to order. I want to welcome you all here today. Can we have roll call, please?
Commissioner Alborn?
Here.
Commissioner Allen?
Here.
Commissioner Karapetka?
Here.
Commissioner Locke?
Here.
And Chair LePage.
Here. Okay. Brings us to the public appearances. Any member of the public may address the Planning Commission at this time on any matters of municipal concern which are not on our agenda tonight. Items will not receive discussion, but they may be agendized for further discussion at a regular meeting. I remind you, we are all under the governance of the Brown Act, and you will be expected to abide by that. So at this time, I'd like to invite any members of the public to come and address us about any matters of municipal concern which are not on our agenda tonight. Got one hand up? Okay, nobody in the chamber coming up. Nancy, you have your hand up. You'd like to speak to us?
Yes, just wanted to thank you guys all for the above and beyond work that you're doing here this month. 4 meetings, one that was kind of aborted a little bit, but just showing our appreciation. Good results from last night from where I sit, and thank you very much.
Thank you for your comments, Nancy. Okay, no further hands up. Last call for the chamber. All right, we will move on to the consent agenda. Items on the consent agenda considered to be routine in nature and do not require discussion, but any members of the commission or the public may request items be pulled for further discussion or questions. Tonight we have 3 items: the monthly activity report, the minutes for the commission January 21st and February 4th special meeting minutes. Any questions? Any questions from the public? In that case, I will make a motion that we accept the consent agenda as presented.
Second.
Okay, roll call, please.
Commissioner Alborn?
Yes.
Commissioner Allen?
Yes.
Commissioner Karapetka?
Yes.
Commissioner Locke?
Yes.
And Chair LePage.
Yes, motion is carried. All right, that brings us to the public hearings. The first item of the public hearing tonight is the annual general plan and housing element progress reports. I believe Marnie Waffle is going to be presenting that.
Well, thank you and good afternoon. So this afternoon, the Planning Commission's going to be reviewing the 2025 annual progress reports. So there are 2, one for the general plan and then one more specifically for the housing element. So each year, the city prepares and submits annual progress reports on the activities taken to undertake the general plan. These reports are submitted to the Office of Planning and Research, which is now the Office of Land Use and Climate Innovation. A separate report on the implementation of the housing element is submitted to the Department of Housing and Community Development, which we commonly refer to as HCD. Both reports are due annually by April 1st, and before submitting those reports, they are reviewed by the Planning Commission and the City Council. So I'm going to start first with the general plan report. Just a quick overview. Our general plan has a number of different elements, which are basically just different chapters. They are listed here, followed by the year that each one was most recently either adopted or updated. Because we are a coastal community, we also have a local coastal program. So the LUP that you see next to the general plan element is also part of our local coastal program. So just some general highlights from the general plan and local coastal program. We did not have any general plan amendments during calendar year 2025. We did have 2 amendments to our local coastal program, and that was updating our wireless telecommunications regulations and then adopting our updated historic context statement. Under the land use and community character element, so what I'm gonna do is I kind of go through is I'm just gonna mention some of the highlights of the activities within each element that were undertaken in 2025 to implement each of these categories within the general plan. So the Planning Commission considered 40 applications of residential design studies. Within the circulation element, the Traffic Safety Committee met 3 times in 2025. They recommended some additional stop signs to enhance pedestrian safety, and those stop signs were installed. Under housing, just generally, the council allocated 14 acre-feet of water. They entered into a professional services agreement with Opticos Design to prepare the objective design and development standards. They also updated the city's reasonable accommodation policy and accepted the annual progress reports for 2024. Later on in the presentation, I'm going to go into more detail on the housing element report itself. Some other policies that were implemented, city continued the active short-term rental enforcement, which is consistent with our coastal access and recreation element. Under coastal resource management, the city undertook an assessment of the 4th Avenue outfall. The council held a discussion on architectural copper and then adopted a ban on the installation of artificial turf. Under public facilities and services, there was quite a bit of work done in 2025, including numerous conversations about the Carmel Police and Public Works building upgrades. We also implemented the audiovisual upgrades in the council chambers to enhance our public engagement during our meetings. The fire station upgrades to accommodate a new fire engine. And then also kicking off the Harrison Memorial Library Restoration Project. Under the open space and conservation element, the city installed some electric vehicle charging stations up at Vista Lobos and purchased 2 electric vehicles for our public works fleet. Under the environmental safety element, Carmel Prepares held 2 workshops. The city engaged an emergency preparedness work group. We updated the fire hazard severity zone maps and then also the emergency operations plan. Under the noise element, the city council did ban pickleball at Forest Hill Park and then also continued enforcement of gas-powered leaf blowers. So this is just kind of a general overview of the activities that were undertaken in 2025 to implement the policies in the general plan. With respect to the housing element, while it is part of the general plan, HCD has a more robust kind of reporting requirement for the housing element. They actually provide standardized forms that we're required to use when doing our reporting. So as the Planning Commission is now very familiar, our housing element is updated every 8 years. We're currently on the 6th cycle update, and it was adopted in April of 2024. We have now posted our annual reports for the 6th cycle on our website, so you can find 2023, 2024, and now the current 2025 reports there. So the housing element report tracks all new housing construction during this 8-year planning period, which is 2023 to 2031. And we report this to the state on an annual basis. We're also required to report to the state our progress in implementing each of the programs that's in our housing element. And again, the state provides us with standardized forms in which to do our reporting. So the forms come in an Excel file, and there are a number of tables. Some of the tables do not apply to us, so we do not have to fill them out. And you'll see there on the 5th bullet down, I've listed the tables that are not applicable to us. But in Table A, we report the number of new development applications submitted during the calendar year of 2025. Then in Table A2, we report the number of building permit applications that we have approved and issued. And then we also report the number of certificates of occupancy we've granted. So that's basically the number of building permits that have been finalized. Table B, it's a summary of our progress in meeting our regional housing needs allocation. So it's keeping track of all the net new housing units over this 8-year planning period. And then Table D is where we report on our progress in implementing each of the programs. So that's a very text-heavy table. Table L is a new table as of 2025. So the state is now looking for all of the jurisdictions to identify any new sites that have been added to the national, state, or local historic register during the prior calendar year. So this is Table B, which is the summary table that tracks our regional housing needs progress. So you can kind of see here in 2025, we issued building permits for 23 new housing units. So these are not demolition rebuilds, these are actually net new housing units, the majority of which are accessory dwelling units. We do still have a couple of vacant single-family lots in Carmel. So there's a couple of those in there as well. And so to date, starting from the start of the planning period in 2023, there have been 51 net new housing units towards our housing needs allocation of 349. And of those, 48 are market rate units. We were able to capture 3 lower income units within the 2023 planning period for a couple of those accessory dwelling units under an interesting formula that HCD allowed us to use, and I can answer any questions if you have any regarding that. So this is the current status of our regional housing needs allocation, and then you can see the rest of the columns throughout the planning period. We'll keep populating those each year as we go. So staff's recommendation is that the Planning Commission adopt a resolution recommending that the City Council accept the annual reports. And that concludes my presentation. I'm happy to answer any questions.
Marty, can you explain the formulation used by ACD regarding low-income ADUs?
Yeah, so there was a formula, I don't know how to say this simply. One of the region up in the Bay Area, they undertook a study that found that many accessory dwelling units are sort of affordable by design in a sense. So by the nature of their small size or the fact that they're being utilized for elderly parents or caretakers, they're naturally affordable. So the state said that even though they're not deed restricted, there is a certain percentage of accessory dwelling units that are naturally affordable. So they allowed cities to count a certain percentage as lower income, but they only allowed that to occur for a certain period of time. And for us, that was the 2023 time period. So that's why we were able to log 3 non-deed restricted ADUs as lower income for 2023. Going forward, we're gonna have to provide some new analysis to justify that if we're going to continue reporting them if they're not deed restricted.
Is it primarily the rent amount that they're asking, or is it have to do with square footage still, or?
We would have to produce a more local-based report that demonstrates that they are affordable, whether it's based on size, occupancy, or the rents being charged to justify it.
Good, thank you. Any other questions for staff? Okay, thank you. Okay, this time I'll invite any members of the public that would like to come forward and speak to us about this report. Nobody in the chamber, oh, there we go.
Thank you for your service and time. Regarding the traffic commission, the stop signs that were added, is it possible to make recommendations at this point still, or is it already null and void at this point? I live near MONTE and 9th, and it's a very precarious situation because of the way cars are parked, as well as trees and so forth, and to the point where I'm very cautious, but I've even pulled out in front of a police officer because it is so hard to see around cars. And I know we have plenty of stop signs in our community, and, you know, there's probably not need for much more, but I just wanted to leave my input because it is a precarious intersection there at MONTE and 9th. So, that's all. Thank you.
Okay, thank you. Marty, did you want to comment on how the comment periods works, or the director?
Since it's not relative to really the report, I will share my information with you. I sit on the Traffic Safety Committee, and then we can work together.
So contact traffic safety.
I'll share my information with you, and then we'll work together.
Thank
Get
you.
that done.
Thank you.
Thank you. Okay, anyone else from the public that would like to make a comment at this time? Okay, don't see anybody, any hands up online? Okay, we have the commissioners, any comments?
No, I would make a motion to accept the report as presented.
A second?
Okay, any further discussion? All right, roll call, please.
Commissioner Alborn?
Yes.
Commissioner Allen?
Yes.
Commissioner Karapeka?
Yes.
Commissioner Locke?
Yes.
And Chair LePage?
Yes, motion is carried. Okay, that brings us to the next item on the public hearings, which is a director referral. This is continuation of the October 8th, 2025, and other commission meetings and hearings regarding the SHUCKS Cocktail and Oyster Bar.
Alrighty. Thank you, Planning Commissioners. Anna Jeanette here to present on the Director's referral on AW-SHUCKS. So this item was continued from the October 8th, 2025, December 10th, 2025, and January 21st, 2026 hearings. Subject property is located on Ocean, 3 southwest of San Carlos, and the zoning is Central Commercial, or CC. Just to go over a little bit of the background that was included in the staff report. In the 90s, a use permit was approved, stating that a drinking place was the primary use and allowing light food as an ancillary use. Then there are a series of building permits that were issued by the city, allowing a commercial upgrade to the kitchen. Then in 2015, the Planning Commission at that time designated AW SHUCKS as one of the 3 drinking establishments. Then in 2023, there was a business license that was issued to the current operator and an email from the planning director at that time with the determination that AW SHUCKS was legal nonconforming. Then on December 10th, 2025, staff presented the Planning Commission with 5 options that are shown here on the slide, ranging from allowing them to continue as is or through an amendment of a use permit. Ultimately, on the 10th, the Planning Commission considered the information, took public testimony, deliberated, and directed staff to come back with a resolution for a determination of abandonment of the use permit, and also stating that the preference for moving forward was through option 5, which would be to amend the use permit, omitting the drinking establishment and instead replacing it with a full-line restaurant as the allowed use. On January 21st, 2026, staff received correspondence for that hearing. The correspondence was provided by Hudson Martin PC, which was an attorney firm representing the owners of the subject property, TSD Carmel Properties. Our city attorney here today, Brian Purick, has reviewed the Hudson letter, and there were specific statements relative to vested rights and estoppel. And at this time, I can pause and allow Mr. Purick to add any additional information, should you wish.
Yes, thank you. So you have in your packet the staff report, and under the heading of correspondence received for the January 21, 2026 Planning Commission hearing, there's a discussion which confirms that I have reviewed the January 21, 26 letter from the Hudson firm. They are the attorneys for the property owner. I can add that I've also reviewed the letters from the JRG law firm. Those are the attorneys for Parker Logan. And I also reviewed the letter from the Fenton law firm that are the attorneys for the owner and operator of AW SHUCKS. And based upon that review, it's my belief that if the commission were to determine that the current uses of AW SHUCKS constitute an abandonment of this drinking establishment, then that determination would be subject to legal challenge based on the record as described in the factual chronology before you in the staff report. And while it is not possible to predict with accuracy how a court would rule in the event of such a legal challenge, there is a risk that a court might find that the doctrines of vested rights and/or estoppel apply based on the current record. One thing I can tell you after a few years of experience is that litigation takes time, it takes money, and there's an uncertain outcome. So it's my understanding that that AW SHUCKS was brought to you in October of 2025, and part of the motivation for that was communications that the city had received prior to that time regarding the use permit. And the issue then for you this evening is to determine which of the 2 alternatives, I'm calling them alternatives instead of options because I don't want to confuse it. It was called options in the December 10th, 2025 report. So what you have before you this afternoon are those 2 alternatives, and those include resolutions that are described in the staff report, including a resolution regarding abandonment and also regarding an amendment to the use permit. And then the second alternative would be a resolution directing staff to communicate with AW SHUCKS regarding an amendment to the use permit to omit limited food service and add a full-line restaurant as an ancillary use that is greater than 10% of the primary use. So those are the 2 resolutions before you. The second alternative, if you will, in terms of communicating with AW SHUCKS, I can tell you that in reviewing the correspondence from the Hudson firm of February 11th of 2026 and from the Fenton firm of 2026, it appears that ADJOURNMENT would be amenable to having that discussion regarding an amendment to the use permit. Before you do not have before you an application to amend the use permit, which is why it is stated in the staff report and the resolutions that that would require the consent of ADJOURNMENT and the property owner. So that's what my analysis is. I'm prepared to answer now or later questions that you might have.
My question.
Good.
Thank you very much for your presentation on that. The question is if the owner of ADJOURNMENT were to apply for, you're saying an amendment to the use permit to allow greater than 10% of the use as the primary use permit, greater than 10% of the use being food service. Is that what I'm hearing?
Yes, they would retain their drinking establishment permit, and the full-line restaurant would be authorized under the amendment to the use permit as an ancillary use.
How does the use permit for the drinking establishment, how does it maintain a use? Isn't that contradictory, I guess, as between those two different uses? Because the drinking establishment use is essentially where the main use is drinking, but if you're not using the main use as drinking, don't they contradict each other by having those two use permits?
Well, I don't think so legally.
Okay. Thank you.
Okay, I had a couple questions. First of all, can you confirm that the Planning Commission has the authority to make decisions about zoning and use permits?
You do, if there's been an application for the use permit, you do have that authority. There is no authority in the code for you to unilaterally amend a use permit.
But we do have the authority to review use permits
Yes.
when they are brought onto our agenda, as in this case.
Yes.
Okay. And in making those decisions, historically, we haven't required that the applicant agree with our decision. We make the decision based upon the findings and the conditions of the use permit. We don't ask for a confirmation from the applicant to affirm our decision. Is that correct?
Well, I don't know what the history is, but I can say that in order to approve an amendment or to issue an amendment to the use permit, it would require the consent of the property owner and of the operator of the business. Now, I don't know what examples you're referring to in the past, and I don't know what actions were taken by the Planning Commission on the prior.
Well, as long as I've been on the Planning Commission, we've never had to ask for consent from the applicants regarding the use permits.
Do you mean amending the use permit?
Yes.
I'm not familiar with those.
Director, do you want to make a
Through the
comment?
chair, the consent would have occurred prior to the application going before the Planning Commission. So once they sign the application, turn that in with the fees, that's a portion of consent. And that's what's missing in this particular case.
So that if a decision was made on a use permit, the applicant would be required to sign the use permit, and that would be essentially consent.
Right.
Okay.
They'd start the application process.
So in this case, on both resolutions, we're just putting that consent up front in the resolution?
Right.
Okay, because normally it's not called out as a condition of the application.
That's correct.
So it's just understood as a condition of the application.
Yes.
Okay? All right, thank you.
I have
Yes, go
two
ahead.
questions for Mr. Perrick. Good evening, Mr. Perrick. My first question has to do with the phrase legally non-conforming use, and I'm referring back to the email that was referred to, the August 14th, 2023 email from then Planning Director Mr. Swanson. stating that the city had memorialized additional cooking equipment, creating a legal non-conforming situation. And my question regarding this has to do with what is the difference between legal non-conforming and simply non-compliant? And the reason for my question is that my understanding was legal non-conforming happens when there is an established and legal business and the law changes, and the business is then not required to change to match the law, that they're given a grandfathered approval. Pardon my vernacular, but that's my loose understanding of what legal non-conforming means. And because a legal restaurant use was not in place at the time that Mr. Swanson wrote that. In fact, there still is not, to my understanding, a legal full-line restaurant use for the business, at least in terms of a use permit. I understand we have business licenses and also building permits that have been approved, but our zoning, in my understanding, is created through and regulated through use permits that are reviewed by this body. Whereas a business license, for instance, and I believe that was the context within which the planning director was making these statements, that is a ministerial approval, the business license, but it is not a zoning change that the planning director cannot independently make a zoning change, that must come before the planning commission. And so since that didn't happen, since we didn't have a legally operating restaurant in place back in 2023 when this legal non-conforming, well-intentioned statement, but that this was made, is this truly a legal non-conforming situation, or is it actually something else, perhaps a non-compliance?
Well, the answer to that depends on who you talk to. There are some views that it would qualify as a legal non-conforming use because it was operating as a restaurant based on the building permits and the business license and the actions taken by this planning commission in 2015. So there are arguments on both sides of that issue.
Swell.
And the other side would dispute that.
I hear you. All right, that's my first question. So I have another question for you. And this does also have to do with the planning director. And the planning director, again, well-intentioned, stating in the email about memorializing the additional cooking equipment and that which created this non-conforming situation. Can that statement by the planning director, can that actually then direct what this body does in the future? Does those statements in email and those actions, ministerial actions by the planning director, does that bind the actions of this planning commission?
Same answer, depends on who you talk to. There's arguments that are
Not helpful.
I know, and I don't mean to be glib.
Of course, and I don't either.
Obviously, we can see that we have multiple legal arguments that are being presented by the attorneys for the various parties, and there's a dispute on that very issue as to the impact of the building permits, the business licenses, the action taken by this commission in 2015, the email from the planning director, and those facts are all referenced in the various correspondence, and there is a dispute among the parties with respect to whether or not as to what the outcome would be, which is why I made the comment when I began my discussion on this issue, is that the outcome would be uncertain if there was a legal challenge. And I also said that if there is litigation, it's going to take time, it's going to take money, and there's an uncertain outcome. So all of that is still true.
One last, thank you, and one last question. And this has to do with the abandonment of use. And because that has gone back and forth about whether or not there has been an abandonment of the use of the drinking establishment permit. We did hear at previous meetings where this use permit was heard, we've heard from the owner that they're operating as a full-line restaurant, not a drinking place with a limited food service. We've heard that from licensing documents, their business license calls out a full-line restaurant. Their liquor license is a full-line restaurant, not an alcohol license, bar-type license. We also heard from the owner that their revenue structure is supported by the full-line restaurant, not by a drinking establishment. All of this seems to confirm that the current primary use is as a full-line restaurant, and so, which is actually outside of what the use permit authorizes. Doesn't that constitute an abandonment of use?
I'd give them the same answer as I had before, so I'll rephrase it, but it means it gets down to the bottom line. There's a dispute on that issue of whether or not the use has been abandoned. There's legal arguments on both sides of that issue. They're set forth in these lengthy letters from the lawyers. Lawyers tend to write lengthy letters. And I've reviewed them, and you have arguments on both sides of the issue as to whether or not they would be permitted to continue to operate in the manner that they are now, based upon, and I don't want to repeat myself, but let me call it the record that's before you in terms of the building permits, business licenses, previous actions by the commission. All of that is viewed by attorneys with a different conclusion. And I can tell you what my conclusion is, which is that if we were in a court, and with that being the legal challenge, there would be an uncertain outcome. I cannot predict how a court would rule if this case were presented to them. But I do know that litigation is something that takes time, money, and there's an uncertain outcome. And alternative 2 does give an opportunity for the restaurant to continue to operate as it has with an amendment to that use permit. And if you choose option 1, you can do that. I've just tried to give you the best advice I can about what the potentials are.
Thank you.
I have another question for you. Isn't it true that if they were to amend the use permit to full-line restaurant, that they could continue operating exactly as they are today, and that they're really, that having that drinking establishment use permit actually does not impact how they're operating? That's right.
That the restaurant would, the business would continue to operate as it is. The assumption would be it would continue to operate as it currently operates, as a drinking establishment, and then as a full-line restaurant, as an ancillary use under what I'm calling alternative 1. And by the way, I should mention that there was a comment made about the liquor license, and that's not an issue that's relevant to your consideration today. That is an issue for the ABC, and it's not something that is within your jurisdiction. And I think I've covered all the points now, but if there's others.
Okay, thank you. We may ask you further questions as the discussion proceeds. Okay, is staff done with their presentation? Or?
I just have a couple more slides.
Okay, go ahead. Please continue.
I did want to touch on, there's additional correspondence that was received. As of today, in summary, some of the correspondents agree that the use has been abandoned based on the conditions of approval for the original permit, how the AAW SHUCKS operates, and recommends the Planning Commission consider the draft resolution in attachment 1. There's also correspondence that was received in summary stating that the use has not been abandoned based off the history, vested rights, and recommends the Planning Commission consider the draft resolution in attachment 2. And then in case during deliberation, the commission needs a breakdown of what's written in the staff report. This slide shows the actions in attachment 1, and this slide shows the actions in attachment 2. That concludes our.
Okay, thank you. Questions for staff? Okay, thank you. All right, at this time, I'd like to invite the property owner or the business owner to come up and make their comments before we open it up to the general public and any legal representation that they may have.
My suit gave me away.
Pardon?
My suit may give me away as legal representative. My name is Christina Gobelsman. I'm an attorney with Hudson Martin, the law firm that represents the landowner, TSD Carmel Properties LP. Based upon the comments that were already made earlier today, it's clear that you've had the opportunity to review the letters that were submitted by our firm and the legal arguments that were presented therein with respect to the two alternatives that are being considered here today. I'm not going to belabor the points in those letters since you've already had the opportunity to review them and consult with the city attorney regarding them, but for the purposes of ensuring a clear record, I will note that TSD Carmel Properties LP does object to the proposed adoption of draft resolution in alternative 1 that is also labeled as draft resolution attachment 1 in the agenda packet for today's meeting. TSD has continuously asserted that it has never abandoned its use permit, that it has in good faith relied upon communications with the city in ensuring that the use permit was being carried out in a manner consistent with the existing laws, ensuring that it was renting its property to tenants who would be able to use the drinking place use permit. And it was in reliance on those representations from the city that TSD worked with SHUCKS and their new owners on a transition of that business in 2023. The bases for TSD's position are set forth in the letters that you've already received. They were detailed also in another manner in communications that were sent by SHUCKS legal representative with Fenton and Keller, as well as in prior statements that were made on the record in the prior public hearings. The underlying facts are also well established in the record. They were reviewed again here today. And just again, for the sake of completing the record, the legal arguments that TSD is asserting include those relating to vested rights, estoppel, and an improper government taking if there were to be a deemed abandonment of the use permit and potential reissuance of that use permit to another business. Similar concerns, of course, were also raised by SHUCKS in its letter. We also indicated in the letter that was submitted earlier today that TSD agrees with the adoption presented in Alternative 2, and that is the adoption of the draft resolution that would provide for the continuation of the existing drinking place use permit and the amendment of that permit to omit the limited food service and add a full-line restaurant as an ancillary use that is greater than 10% of the primary use. That amendment, as already discussed today, would require the consent of both TSD and SHUCKS. That consent has not yet been provided, but certainly this is an option that TSD and SHUCKS are both interested in pursuing. They are on the same page. They want to be able to continue with the businesses in operation. They want to be able to continue with the use permit that they have been benefiting from. TSD has held this permit since 1961. And again, is interested in continuing with the same sort of discussions that it has had previously with the city in ensuring that it can maintain that drinking place use permit. There were several questions that TSD had with respect to the draft resolution, alternative number 2, and that would be what next steps would be envisioned by the city and by the commission in terms of being able to pursue that alternative. We want to ensure that to the extent that there are additional conversations, that they are held in good faith, that we have a clear understanding as to what the path is forward, and that we're able to move forward productively with respect to ensuring that the use permit can continue on as it has been with the amendments that are being contemplated in the draft resolution. And that is the extent of my public comment on behalf of TSD Properties today, though the property owner is also present.
Thank you. Any questions for the attorney representing the property owner?
Yes, good evening, thank you. Would you please speak to a little bit more to what you mean when you say vested rights?
Yes, so this was detailed in the 2 letters that were submitted by the law firms earlier today, so I apologize if what I'm going to say may seem repetitive of what may have already been covered in those letters. But what you have here are 2 businesses that have been in operation for a number of years. They have a legal right to the continuation of their businesses, and they should be able to continue their operations as they have for the last several decades, notwithstanding the fact that A.W. SHUCKS had recently changed ownership in 2023. To the extent that the city is looking to come in and take away a use permit that would impact their operations, that, from the perspective of our client, TSD Carmel Properties, would constitute a violation of the vested rights that they have with respect to their operations, to their business, and to that use permit. Again, they've had it since 1961, and so this isn't as though they have come up to the commission for the first time seeking the approval of an application that had not been otherwise previously considered.
So it sounds like your position is that somehow the business would change if there was if the use permit was actually normalized to the way that business is being operated today.
There would be a change in the value of the tenant space that our client, TSD Carmel Properties, operates. They are the landlord of the building. They rent the space to tenants of a certain type that meet the profile for the drinking place use permit. That is why the owner of the business contacted the city prior to the change of ownership from the previous owners of A.W. SHUCKS to the current owners. There was an interest in ensuring that if they were representing to that particular tenant, that they would be able to operate under the use permit, that would be correct. If the city were to now come in and say, we're going to be deeming your use permit abandoned, even though you've consistently indicated you want to retain it, even though you've consistently communicated with us regarding it, even though you've continued to lease your property to a tenant that you in good faith believed actually had the right to operate under that permit, if you just come in and say that's abandoned, then our client can no longer focus on letting that space to the types of businesses that would fit the profile permitted by the use permit. And since they're already in a contractual relationship with a tenant regarding that space, and based upon the prior representations of the city, let that space to that tenant, of course, there's an interest now on behalf of our client to pursue the second alternative that's being presented today, which is to amend the use permit to allow that tenant's business to continue. Otherwise, there could be harm that could come to our client.
Thank you.
I have a question on that, just a follow-up question. You did say that it would impact operations.
That is correct.
Okay, so specifically, how would it impact operations of A.W. SHUCKS?
My client is not A.W. SHUCKS. My client is TSD Carmel Properties. They are the landowner of the building. They are the ones who let the space to a tenant business who is able to make use of the use permit. If the use permit, drinking place use permit, is removed, that will change the operations of TSD Carmel Properties in terms of whom they can let the tenant space to. It may impact the ability of them to let for the same amount of rent to which they have been letting before. There's a certain amount of attraction in having a drinking place use permit in Carmel when there's currently only 3 allowed. And certainly the fact that there's scarcity with respect to that use permit does give it value to our client and can make that particular tenant space of interest to other business who would want to make use of that use permit. In fact, it seems as though we may be here today because there may be other businesses who are interested in having that drinking place use permit. So there's certain value there, and there would certainly be an impact on the operations of my client, which is the landowner. I can't speak specifically to A.W. SHUCKS. I would need to defer to them and to their legal representative.
So I have a follow-up question. What is the lease term with A.W. SHUCKS?
That is a wonderful question. I don't know the answer to that off the top of my head, but the owner of the business is here today, and when he comes to the podium, he can answer that question for you.
Thank you.
Thank you.
No further questions. Thank you for your time.
Just a minute, I think the property owners, let them come, we'll kind of keep
Thank you.
the arguments together.
Evening, Commissioners. John Plastini. I represent TST Carmel Properties, the property owner and landlord of AW SHUCKS. I'm sure you're well aware this is our fourth meeting, okay? I'd like to say that when we first looked at this, staff contacted us and communicated that there was a problem with the paperwork and we needed to fix the paperwork. Option or resolution 2, whichever one, does that, okay? And I think our attorney explained the reason behind that. We're talking about, well, how are you affected? The property value itself. Our tenant is here. They purchased it in 2023 for a great deal of money. And I've checked, that use permit is worth about $250,000. Do we want to go out and start bidding that? We don't. The mere fact is an individual that wants it so badly should tell you there's a value. We've counted on that representation as far as a drinking establishment. We had it for 65 years. When we market the property and we lease the property, everyone knows that. When they purchased the property, they did that. As far as we follow the rules, we acted in good faith. I even went to the extent when the purchase happened to make sure we were okay. The only reason we're here, because one individual, okay, needs that permit. That's what the value of it is. What began as a simple inquiry regarding a land use permit transitioned into a campaign to take away our land use permit. For over 65 years, we've had that permit, okay? Using the closing of SADE'S as a reason to strip us of our land permit, okay, is not a viable legal option. I think the attorney said, what do we have? What's going to happen here? We're going to all wind up in court. That's what's going to happen. And I'm pretty confident I get there in front of a judge and I said, Your Honor, we've been here for 65 years. We followed the rules. We acted in good faith. And they stripped it away from us. And it has this value. Talk about damages, the legal costs on all ends. The city's burden, have no idea. You've been here 4 times? We want to continue this? Anyway, in addition to that, I wanted to notice, beyond that, the problems that we've had with our tenant. She can't even come up here and speak tonight because she's so upset. She's been intimidated. I believe you have that letter that she sent in, okay, of the behavior, of the intimidation I have received also, only because we want to continue to operate the way we've had for 65 years and be left alone. We've been ridiculed in the paper. We're the victims, okay? SADE'S isn't. We're not responsible for SADE'S closing. If you want a path to save SADE'S, change your regulations. That's where we need to go. That's the proper path. Hurting someone else and taking it and giving it to somebody else is not the right thing to do. And I think if we go to a court, I think a judge is going to look at that. I don't want to go there. But just to document a few things here. Parker Logan, after the first meeting that we had in October, sent me a number of texts. To me, they were intimidating, okay? I expect it as a landlord. You get that. You rub it away. But I just like to share you a few of where we're at here. He said, everyone wins if you endorse the fact that AW SHUCKS operates as a full-line restaurant. Otherwise, there'll be a big fight, what eventually leads to a courtroom, because it's clear the Planning Commission is going to side with you. That will be appealed and have this process drawn out, and it could mean bad press for AW SHUCKS. That's already happened. Have you seen our name in the paper? No. But these poor individuals that came here and bought this business in 2023 don't deserve that. And what I didn't deserve after the commission meeting on the 21st of January, to have that lady come in my office crying because of the incident that you have, okay? It just goes on and on. That if we don't give this up, we're going to be reported to the state, and then we're gonna be looking at ADA violations. Come on, really? Anyway, couple other things. The last thing I wanted to read was, after the incident on January 21st, Parker Lowe sent me a text, and this is what he said. "Well played, sir. Dirty, unheroic, slimy, but still well played." That's an insult. All we are doing here is having our rights defended by our attorneys. We didn't bring an attorney in until 2021, January 21, because we were getting all slammed here, and we have vested rights. We've been in the community so long, and all we want to do is operate the way we have. It wouldn't even come up unless SADE'S needed it. If he wasn't here, we'd be operating, it wouldn't come before you. Anyway, so in kind of going through that last comment there, it's clear that we have a different definition what a hero is, okay? I believe a hero stands up for its vested rights, which we have. He stands up to intimidation, which we're doing, okay? We stand up against bullies, and we protect the innocent, because those people don't deserve this. And it's all because of what's happening because of a desperate individual, and that's wrong. Anyway, I believe, the resolution number 2 is in the spirit and the intent of what we talked about. I've trusted the city. I've worked with the city. I love working with the planning department. They even recommended number 2. These people work so hard and try to sort through this stuff. I don't know how they do it. To me, when they recommend something, it is hard on you. I understand that. But when I look at this and I say, let's just fix the paperwork. That's what you told us. We'll act in good faith. We will work with the city. We can make the land use and the business use match because you have a problem with that. It's legal and non-conforming, and we can make that happen together. You don't need to strip our use there because we will wind up in court, and it's going to cost a fortune. And according to Parker Logan, it doesn't matter. He's going to appeal it anyway. I don't know what rights he has to appeal. It's our application. It makes no sense to us. So I guess finally you're going to have to decide, who do you want to see in court? Us or him? But it's going that direction. And it's going to cost a lot of money, and it's going to be probably years. But I hope you look at it and go and approve number 2 there. And I thank you for your time, and I look forward, hopefully, to work with staff again.
Mr. Palestini?
Yes.
Will you please respond to my question, which is, what are the lease terms and length of time?
I believe there's 9 years left.
Okay, thank you.
And that doesn't mean that we wouldn't renew it. They're good tenants. Any other questions? Thank you so much for your time. I appreciate it.
Thank you for your comments. Okay, at this time, I believe, I'm sorry, I forgot your name.
Derek Oliver.
Right, Garrett, if you'd like to come up.
Chair LePage, commissioners, council, and staff. My name is Derek Oliver. I represent the owners of the SHUCKS establishment. And sadly, I guess I now have a better understanding of why drinking can lead to fighting. But as the property owner correctly stated, and I think was stated in the staff report, the use permit runs with the land. So my clients are sort of are passengers on the train of the landowner who is sort of driving the train in this dispute. But with that said, my clients certainly agree with, as set forth in our letter, the position that the landowner is taking, and for all those reasons. As to legal nonconforming, what is it? What's legal nonconforming? Legal nonconforming is a legally established use, a use that was established under the laws or in the absence of laws at the time the use was established, and that was the case here. So the drinking establishment use was established before the codes that said a drinking establishment means this, you need a use permit for that, so it was legally established. What's interesting is the use permit that was issued relates to the addition of food. It doesn't have anything to do with the drinking service. It relates to the addition of food, so it doesn't modify the legally established drinking use. So I think that's just an important thing to point out. And I went over there the other day, took some pictures that I included. I mean, just look at the photograph of the door, of the sign out front. What's most prominently displayed? Oyster bar, cocktails, lunch and dinner are the smallest words on that, which is consistent with what you see when you walk in there. When you walk in there, and you look, not even walking inside, you see a giant bar with beautifully displayed, lit up liquor and wine, and the whole bit. I mean, if it looks like a duck, quacks like a duck, that's a frickin' bar. And the oyster bar in the corner is also a bar. So there's no need to go beyond the legal arguments made in the letter, but I happen to have had the coincident benefit of being here at the December 10th hearing on another matter, and so I had the benefit of that 2-hour discussion. And it struck me that both sides have competing interests, and both are valid competing interests. And it just seemed to me that there ought to be a way to solve the problem. And as the last speaker just suggested, and as I tried to explain in my letter, this shouldn't be and doesn't need to be an either or. There is a win-win here, and there is a code section that specifically talks about uses that don't fit into one bucket or another bucket. And if the city wants SADE'S to have a license to operate as a bar, I certainly do. Well, then the city has the power to review its codes, amend its codes, and create either a fourth license in this same category or create different categories, perhaps categories based on the type of liquor license. So if you're 21 and over and it requires a ABC 48 license, that is the drinking establishment. But to take away a drinking establishment license just because they're serving more food doesn't mean they've abandoned that use. Increase of one use doesn't mean abandonment of another use. And the last time I checked, having more food options at a bar isn't ever really a bad thing. So I would just humbly submit that, as has been said before, my clients, as with the property owner, ask that you strongly consider and adopt resolution number 2 for all the reasons that your counsel explained to you. And then beyond that, to take a look at those codes and try and conform the codes to the realities on the ground and the existing conditions that are designed and implemented to meet the needs and desires of the city and its residents and its business and property owners. So, thank you.
Thank you for your comments. Okay, I'd like to invite anybody else from the public that would like to speak to the commission regarding this application.
Good afternoon. My name is Bob Rosenthal. I'm here replacing Jason Redderer, who had a family matter come up at the last minute and couldn't attend. I'm Jason's partner, and I want to address a few things that were said today and a few things that were said in the letters that were received. Unfortunately, we only received the 2 letters today about an hour and a half, 2 hours ago, so I'm not prepared to address some of the comments in it, but they're pretty much repetitive, so I think I will be able to attend to them. This case is about a use permit. It's not about litigation or threatening litigation. We're not here to threaten litigation. The frustrations of my client have been expressed. He's frustrated, understandably so, but we're not threatening litigation. I hope you've had an opportunity to review Jason's letter that he wrote in response to Jeanette Witten's letter that challenges the claims and legal authority that Ms. Witten set forth in her letter. Contrary to a narrative that's apparently being asserted by some, both in the town and around the community, it needs to be made clear, I think, to at least to the people in this room, I know it's clear to you folks, that no one is asking to shut down SHUCKS. No one is asking to keep it from selling alcohol or food, not the city and not my client. There'll be no change and no harm to SHUCKS whatsoever by adopting the proposed resolution number 1. None. Now, Ms. Whitten, in her letters and the letters from all the attorneys, they all talk about the harm that's going to be suffered, that there will be harm, but they don't tell you what that harm is. There's no harm that's going to be suffered. SHUCKS is going to continue to operate exactly as it has if you adopt resolution number 1. There'll be no change. There's no taking, as the lawyers for TSD and SHUCKS have claimed. First, there can be no taking, as a use permit was abandoned when SHUCKS began operating as a full-line restaurant. And I respectfully disagree with counsel. I think that there is an abandonment. I think if you look at not just the facts, that they being SHUCKS, went and asked for a building permit to build this kitchen. When they did that, that was an abandonment of their use permit for a drinking place. Your statute on abandonment says a restricted commercial use that has been discontinued for a period of 6 consecutive months shall be considered abandoned. A restricted commercial use. That restricted commercial use, in this case, is a drinking place permit. That's the use. Failure to maintain a valid business license shall be considered substantial evidence of abandonment. The business license that we're talking about, as was pointed out by I think Ms. Locke, the business license is classified as a full-line restaurant. That's the business license. The drinking place permit, business license, has been abandoned. Your own statute supports abandonment. The fact supports abandonment. I agree that there's a disagreement, but I don't agree that a court is going to rule in favor of there being no abandonment. And I'll talk about that briefly in a second. There's no taking. The resolution amends, the first proposed resolution amends the use permit to allow SHUCKS to continue its business. It will continue it, as I said, unchanged in any way. And third, for there to be a taking, and this is most important, for there to be a taking, the law requires there must be a substantial economic impact or loss. What is the substantial economic impact or loss? The lawyers say there's one, but what is it? SHUCKS will not close. SHUCKS will not change operationally. SHUCKS will not lose $1 by adopting the first resolution. TSD asserts that the proposed resolution would, and I'm quoting here, interfere with SHUCKS and TSD's ability to continue their business. So the city should be stopped from amending the use permit. How is that resolution going to interfere with SHUCKS' ability to continue its business? It specifically states it's going to continue it. It's going to amend the use permit to allow it to continue. It's just simply not true. It is not the law that because a city historically has allowed a business to operate, as here, SHUCKS, beyond the use permit restrictions, that SHUCKS can therefore continue to operate in violation of the conditions of the permit. That's not the law. Just because there's been a mistake made or they're violating it doesn't mean we get to continue to violate it. The city has a duty to enforce its code. You can't be stopped from enforcing permit conditions or the code simply because you failed to enforce a use permit's terms in the past. That's the law. The staff says in its report that the city attorney believes finding an abandonment might subject the city to a legal challenge. Well, anyone can make a legal challenge. I think that was pointed out by counsel. But there can only be one prevailing party. If there is a legal challenge, the court's going to require a review of the city code, and specifically a review of section 1756.050C. That's the code I read earlier, part of. But it'll also require the TSD and SHUCKS prove substantial prejudice. Prove that they will suffer substantial prejudice from the adoption of that resolution. There's no substantial prejudice, as I pointed out. They're not going to prevail in a legal challenge. Jason is a land use lawyer. I'm a litigator. I've tried hundreds of cases. I can tell you, in my opinion, differs from counsel's. They will not prevail. And I believe that Ms. Witten knows that. And I believe the threat of litigation that you heard here today is simply that, a threat, a veiled threat. There's also unintended consequences I think the commission needs to consider by adopting the second proposal. The second proposal retains as the primary use the drinking place and converts the ancillary use from limited food service to full-line restaurant. Well, the result then is going to be that you're going to have two primary uses attached to one permit. That's not what the code intended. When your code defines the limitations on restricted commercial uses and lists them, full-line restaurant is one of those uses, as is drinking places. Those are primary uses. To suggest that you can adopt a resolution that effectively eliminates the distinction between a full-line restaurant and drinking place is just going to cause havoc. The other thing I think that might occur is, think about if you adopt that second resolution, whether it would provide precedent for the city's two other drinking places to now claim they have the right to have a full-line restaurant as an ancillary use. There's a few other things that were commented in front of you here today on the vested rights.
Can I just interrupt a minute? How much more time do you think you're going to need?
30 seconds. I'll wrap it
Oh,
up.
perfect. Okay.
Okay. You know,
I mean,
try to get a lawyer to.
I'm not trying to restrict you. I'm just trying to define our time agenda.
enough.
So
Fair
if you
enough.
need 2 minutes,
And I do
whatever,
not want to.
I'm fine with that.
I
But
don't want to bore anybody. Vested rights are limited to those rights that are contained in the use permit. Operating outside of that use permit does not extend those rights and make them vested. Finally, we've talked about ancillary use or accessory use. Your code section 1770.020 defines an accessory use as a use that is secondary to the principal use, incidental to any permitted use made on the premises. It goes on to say that a drinking place is defined as businesses serving beverages for consumption on the premises as a primary use. And restaurants, it defines restaurants as full-line restaurants, as restaurants providing a full line of prepared food and drinks. That's what we have here. So to adopt the second draft resolution flies in the face of your code, flies in the face of common sense, and to think that you're avoiding a fight on the issue of abandonment, I don't think you are going to have a fight. I think there's abandonment here. Thank you.
okay, thank you for your comments. All right, I'd like to invite anybody else who would like to come up and make comments about this. Please come forward.
Good evening, Commissioners. Just wanted to make a quick comment as a resident of over 40 years of Carmel-by-the-Sea and a payer of a lot of taxes here. As a citizen, I view a use permit as a civic asset and one that ought to be generating tax revenue for the city and all the other entities. And, you know, the fact that just listening here to the presentation of AW SHUCKS and TSB, it comes off to me that they're hoarding a civic asset that ought to be working for me as a citizen, producing taxes so that mine don't keep getting raised. Thank you very much.
Okay, thank you for your comments. Any more speakers like to come forward? Okay, any hands up online?
We do, yes.
Can you kind of switch my screen over so I can see them?
Just one.
Just have one?
Yeah, just one. Lindy Dowd.
Okay, Ms. Dowd? Ms. Dowd, do you want to speak?
Yes, can you hear me?
We can hear you, go ahead.
Okay. I'm Lindy Dowd. I'm one of the owners, and I appreciate your time. When my grandfather built the Dowd Arcade 65 years ago, the space that A.W. SHUCKS now occupies was Whitney's, a true dive bar right in the center of downtown Carmel. I never saw the inside of it since no one under 21 was allowed. But I did have to pass by it every time I visited my father at work after school, as he was a dentist practicing on the second floor of the Dowd Arcade. I held my breath to avoid inhaling the strong cigarette smoke. My uncle Bob Fisher was a policeman in Carmel, and I grew up hearing the stories of the late-night calls to that location to break up fights, pull over drunk drivers, or haul someone who had passed out into the station to sleep it off. Cigarette butts littered the sidewalk out front. Well, times have changed, and the evolution from Whitney's to Maxwell McFly's to A.W. SHUCKS is well documented through all the permits through the city every step of the way to its current legal non-conforming use status. The city has applauded this evolution. Management of the building passed from my grandfather to my father to my brother-in-law, John Plastini. Whenever a problem has arisen that needs solving, the overarching management ethos has been what is fair. John has been a proactive, hands-on manager, always keeping up with the city codes, communicating with the city, making sure everything is fair for the tenants and that all the shops comply. When Michael and Michelle Sapon retired after many years of owning A.W. SHUCKS, Karen and Randy Bassi purchased it in 2023 with all paperwork in order and confirmed by the city. So when this item appeared on October's agenda to straighten out some paperwork at A.W. SHUCKS, it seemed a simple but perplexing matter. It soon became apparent that the driver behind this was that another bar, SADE'S, was losing its lease and its owner had come to the city looking for a solution, pulling A.W. SHUCKS into the fray. Now, 4 meetings and many lawyer hours later, hopefully a resolution will be agreed upon today that is fair. But what is not fair is what has happened in the meantime. It is not fair that the Bassis have been bullied and pressured by Parker Logan. It is not their fault that he lost his lease. It is not fair that Parker Logan has sent threatening texts to John Plastini. It is not fair that Parker Logan has continued to rile up his former customers with untruths such as that relinquishing the use permit will cause zero harm to A.W. SHUCKS and that the owners of the Dowd Arcade are just sitting on our use permit. This has got to stop. In closing, I hope this commission will agree on Resolution 2 and will work to address this behavior and restore civility. Thank you.
Thank you for your comments. I see another hand up there. It says Patrick's iPad. Patrick, you want to unmute yourself?
Thank you. Can you hear me?
We can. Go ahead.
Thank you. You have my correspondence posted, but we are here because of what some call sloppy permitting. But for a local business owner, it's called following the rules. For 30 years, A.W. SHUCKS didn't hide its kitchen. The city permitted it in 1998 and in 2008. The city licensed it as a restaurant in 2023. You cannot ask a business to spend decades building a life here with your explicit permission and then suddenly tell them their foundation is illegal. This is exactly what the California Doctrine of Vested Rights is designed to prevent. This drinking establishment permit is more than a menu choice. It is a property entitlement that stays with the land. Revoking it is an illegal government takeover of a valuable family asset. In the Goat Hill Tavern case, the courts were very clear. An existing business has a fundamental right to exist. If the city moves forward with a taking, it is not just hurting one restaurant, it's exposing taxpayers to multi-million-dollar liabilities for inverse condemnation. The city's claim of abandonment is false and fails the simple test. A.W. SHUCKS has never stopped serving drinks. You cannot declare a use abandoned when it has been continuous, licensed, and explicitly protected by the property owner at every turn. Using the closure of SADE'S as a reason to strip a license from another successful business is not planning. It is regulatory favoritism, and it will not hold up in court. Staff has provided a path for reconciliation that cleans up the record without destroying a business. That is the only legally safe path for Carmel. Let's match the paperwork to the reality that the city itself helped create over the last 30 years. Let's support our local businesses by providing a consistent and fairness they deserve. Thank you.
Thank you for your comments. Okay, we have another hand up. Larson Holt, you want to speak to us?
Yes, can you hear me?
We can, go ahead.
All right, good afternoon, commissioners. My name is Larson Holt, and while I'm not a resident of Carmel-by-the-Sea, my fiance Sarah and I are both regular visitors. We all
You've muted yourself, Larson.
Okay, can you hear me now?
Now we can, yeah.
Okay. We almost always bring friends and family with us to share the beauty and joy of Carmel, and we were also regular patrons of SADE'S and went there during every single time that we visited Carmel. I am participating in your Planning Commission meeting today to support option 1, the amendment or removal of the drinking establishment or drinking place primary use for A.W. SHUCKS. While I understand that they are allowed to run their business however they choose, I do not think that a drinking place that closes at 8:30 most days of the week constitutes the average person's definition of a drinking place or a bar. There are 3 drinking place permits in Carmel for a reason, which is so that in addition to all the beautiful restaurants and cafes in Carmel, there are 3 drinking places for the enjoyment of residents and visitors. If the commission chooses not to declare SHUCKS permit abandoned, it means that the commission is effectively allowing TSD Properties, the landowner, to squat on one of Carmel's oh so precious 3 drinking place permits. It would mean that the commission is depriving Carmel of one of the drinking places that are expected to be in Carmel for the enjoyment of Carmel residents and visitors. And it would mean that the commission is allowing TSD and SHUCKS to hold on to this permit for 0 public benefit and solely for the purpose of propping up TSD Properties' values. This leaves Carmel visitors with fewer offerings and leads to fewer evenings and fewer hotel nights spent in Carmel. I also do not think it's appropriate for the commission to not choose option 1 solely based on the threat of potential litigation if it is truly the right choice. Altering this use permit in option 1 will enable Mr. Parker Logan or anyone else who the commission might grant the drinking place permit to open up a new bar establishment somewhere in town that will enhance Carmel's nightlife without creating negative impacts, provide the 3 drinking places that Carmel residents and visitors are legally entitled to, and help create even more wonderful memories in Carmel-by-the-Sea, bringing more visitors and business and keep them coming back. And we believe this will improve the experience for Carmel's residents as well. So I'm here today to request that the Planning Commission make a determination that the use permit of drinking place has been abandoned. Thank you for your time.
Thanks for your comments. Okay, no more hands up online. Oh, no, Neil Cruz. Neil, speak to us. You have to unmute yourself, Neil.
Yes, can you hear me now?
We can. Go ahead, Neil.
Okay, I just want to thank Larson Holt. He basically said what I was thinking about here. Long time tradition in Carmel, you all know, of 3 bars. And that means a bar, where you can go and party on. And that is all. And that has been a fairly tight, certainly don't want to take it down to 2. So 3 is it, and it's not going to grow. And what you're effectively doing is reducing those 3 bars down to 2. And that's a significant reduction of drinking places in Carmel. And I think we have always felt, I was involved with some of these establishments over the years, and we always felt that even 3 was too too strict of a limitation. This should have been 4 or 5. But as it is, this would cut it back down to 2. And so the other sort of a thought experiment I had is if somebody came in and asked you for both a bar and a restaurant use permit, would you give it to them? And I'll stop talking now. Thank you.
Thank you for your comments, Neil. Okay, we seem to be, oh, come on up.
Thank you. I have some words to share with the commission. Good evening, commissioners. As a concerned and engaged member of the community, I appreciate the responsibility you carry in upholding Carmel's municipal code and ensuring the land use decisions reflect fairness and consistency. Permits are binding legal authorizations. They are meant to reflect active, exercised uses, not dormant designations. Land use entitlements are not speculative assets to be held in reserve. They are operational permissions intended to function in alignment with the code and the community's planning framework. The location at SHUCKS has operated as a standalone drinking establishment decades ago. However, for more than 20 years, it functioned exclusively as a full-functioning, full-service restaurant. The property was remodeled to support this use, including installation of a commercial kitchen and a fire suppression system. When the city later limited standing alone drinking establishments to 3, this location continued to count toward the cap, even though the drinking establishment use had not been exercised during that time. I understand the entitlements typically run with the land. At the same time, they remain valid only as long as they comply with the municipal code. Standard planning principles, including the 6-month discontinuance provision, recognizes that prolonged non-use may constitute abandonment. Given the standalone drinking establishment use has not been exercised for decades, it appears that this designation no longer reflects actual use. This does not feel like a policy debate. It feels more like a matter of applying the code consistently and ensuring that limited entitlements reflect real active operations. If you use this effectively, if a use has effectively been abandoned through long-term non-use, it seems reasonable that it can no longer apply one of the city's limited positions and instead be available to someone prepared to actively exercise in accordance with the law. I offer these thoughts respectively and appreciate your stewardship of Carmel's planning integrity. Thank you for your time.
Thank you for your comments. Please come forward.
I'll keep it very succinct. So obviously, there's a lot of big feelings in the room and a lot of rhetoric that I know you all have been hearing for months, and thank you for your time and listening to all of it. And I guess I just want to just be a voice of common sense and reason. You know, you hear threats of litigation, you hear threats of noncompliance, you hear, you know, we hear all of this over and over again. Slander, this, that, accusations, slander. But at what point can the commission consider a 4th use permit? And I don't know if that's something that you can openly answer or if that is even ever on the table. But that seems to be, if things are going to continue to go this way and more attorneys getting involved and more this and more that, and what's to stop a 4th use permit under these special circumstances? I guess that's all. Just wanted to be a voice of reason, possibly. But thank you for your time.
Thank you for your comments. Okay, anyone else in the chamber? And no hands up online, so I'm going to close the public comments and open it up to the commission for their comments. Discussion. Commissioner Locke, you've been writing over here furiously. Would you like to?
Thanks.
You made yourself a target, sorry.
Thank you, I am a target, right. No, first of all, like I've said at all of these discussions in the past, I love the food and the service at A.W. SHUCKS. I have been a very big regular customer for many, many years. And actually, I can go back and say I was at Maxwell McFly's back in the day when I was a minor. I actually am on this one. I really believe that the restaurant is a full-serve restaurant. It is not a drinking establishment. It's not a bar. And I think that when A.W. SHUCKS Maxwell McFly's changed to A.W. SHUCKS, and they added food service, they put in the oyster bar, that changed the use from the smelly cigarette-filled bar that was there, and it became a restaurant. And it has only morphed into a great restaurant through the years. I think that the fact that it is not primarily a drinking place is unfortunately kind of an oversight that staff should have amended that permit earlier so that that was not a part of it. But I do not believe that it has been used as a drinking establishment, and that I would consider it to be an abandoned use on that. I don't think you can lock up something that's not being used. And I have to also say that this has nothing to do with the discussion today that has to do with Mr. Parker. That to me, Mr. Logan, that has nothing to do with my comments. I think that when we have a situation, in particular in this case, when you're limited to 3 of these types of uses in our village, that you have to look at it as what is really happening on this site. And my specific questions about how long is this lease had to do with the question of, is this just going to be locked up for the next 9 years or the next 20 years? And that is concerning. And so I appreciate the comments that were made by some of the members of the public, but I am not supportive of option 2. I would be supportive of option 1 on this.
Commissioner Karapatka, your comments?
I think that's a really difficult one. On one hand, we have this long history of SHUCKS having a designation as a drinking place, and history does matter and tradition does matter. So we have 2 traditions here. Like, one tradition is SHUCKS being designated as a drinking place, but there's even bigger tradition of Carmel having only 3 drinking places. So we have to figure out which one is more important for the community and decide that way. I'm against adding a 4th permit or 4th drinking place to Carmel. I think that is one of the things that make Carmel unique. And we're seeing lately that we are losing some of this uniqueness with, housing, house addresses, et cetera. We have to be very careful not to lose everything that makes Carmel unique and special. So I would say having 3 drinking places is part of what Carmel is, and we should keep it. And I agree with Commissioner Walker that when you only have 3, you have to compromise. It's not easy. There's always a trade-off. If you have 3 people in the desert and only 1 bottle of water, and you have to share it, you cannot just keep it for yourself and say, it's mine, I'll keep it for later. We have to figure out a way to do that in the community. And I think for the benefit of the entire community, we have to figure out a way to free this drinking place designation for more efficient use. Again, I do like A.W. SHUCKS. I enjoy visiting it, and the food is excellent. I haven't tried the drinks yet, but the food is excellent. I do not see that there is any direct harm by, designating it as a full-line restaurant. I understand that there may be some additional consideration in terms of, what people expect when they rent that property from the property owner, but these are things that we cannot really fully control, and we have to make a decision now. Now, if in 10 years, for example, A.W. Shuck changes and becomes a drinking place again, they will be welcome to come back to us and ask for a permit to, use this designation. Maybe at that point, we will say, because of the history of this issue, we'll create a fourth drinking place. Maybe that would be an argument strong enough to do it. But right now, I don't think we're at that level. I don't think we need to do it. So I would be with Commissioner Locke on supporting the designation as a full-line restaurant.
Resolution number 1?
Yeah.
All right, thank you. Okay, Commissioner Allen, your comments, please.
So I'm really torn on this because the business has gone through the channels. They've communicated with the city. They've gotten approvals. Yes, maybe they're not, the approvals that were required for this business or for this land use. But at the same time, like if our word isn't good, then, don't we have to stand by what a city official has told these people? And so, on the flip side of that, I really want to bring this into compliance. And so, number one, I would not say that it's abandoned as of now. I would say that I would give an opportunity to come into compliance. But I don't know, I'm torn on this one because from all indications, the paperwork shows that they were communicating with us, with the city, and they were given the go-ahead to do all of this stuff. So, I don't know.
Okay, thank you. Commissioner Alburn, your comments, please.
Thank you, Chair. And yes, to everything that's been said so far. The go-ahead that the restaurant received was all ministerial. The go-ahead did not happen here at the commission and at the zoning level. It happened at the ministerial level. Does that exonerate it? No. No. But it did happen at the ministerial level, and I do not believe that prior staff level statements bind the planning commission to those statements. But I don't think that they have. I think that this commission is doing its due diligence to try to evaluate this situation in the most neutral way possible. And I think that's essential. I think it's extremely important. And as with my fellow commissioners, I don't take this decision and this consideration lightly at all. I'd like to highlight one of the things that we did receive in our packet was the letter that was sent to Ms. Bassi on August 8th, 2023. And this was her business license approval. Okay, so this is what she received. And it says on the first page, the proposed name is the primary use is of a full-line restaurant. And then on the second page for approvals and conditions, it states that this business license authorizes the use, primary use is as a full-line restaurant, and the ancillary use is a drinking place. And then another paragraph down, paragraph 3, it cites the use permit 93-45, and it states, all conditions and findings of the use permit which was reviewed and approved by the Planning Commission on December 8th, 1993 shall apply to the operation of this business. So we have in our business license conditions of approval, a both and a conflict at the outset. I have a question. Because I, like my fellow commissioners, would like to see this, I would like to see the use permit for this business reflect the operations of the business. Do we have the option of having a use permit that has a primary use as a full-line restaurant and an ancillary use as a drinking place? I mean, we know that ancillary means that it is secondary to the primary, and that does appear to be what the operations are. The operations at this time, and at the time that Ms. Bassi purchased the business, the primary use and all of the applications and licensing related to that are as a full-line restaurant. Can we do a use permit with that as primary and a drinking place as ancillary, or is that not possible in our code? Real question, folks.
Through the chair, I am looking up that information, but going off of memory, I think only the reverse is possible. I believe that the drinking, under the definition of drinking establishment, it has to be primary.
Yeah, that was my understanding as well. Well, in that case, to summarize my comments, I do believe, because of what we've heard, the business license, the revenue structure, the way that the business is operating is indeed in conformance with its business license as a full-line restaurant. And the use permit does authorize the drinking place with limited food service, right? Seafood and oyster bar. And that's very narrow language. That's very, very specific. And I think it's too specific to be able to expand it to include that full-line restaurant. I think it's just too specific. I do believe that characterizing what's happening, characterizing the characterization from 2023 that this is a legal non-conforming use, that the planning director had used that phrase. I do actually feel that that's a misapplication of the term in my understanding of a legal non-conforming, because, and I hinge that on the fact that my understanding is that there was not a legal full-line restaurant use that had been permitted. So therefore, and there was not a change in the law that would cause that legal non-conforming. So I believe we're non-compliant, but we're not legally non-conforming. I also don't believe that this commission is bound by those previous statements by the planning director. Those are ministerial statements that could not apply at the zoning level that the planning commission is required to hear. And my last comment on the estoppel, that is above my. It's definitely above my pay grade in the legal understanding of estoppel. But I'll say in general, and especially with the comments that have been given related to harm, I think that what the commission is trying to do here isn't at all punitive. I think it's corrective. I think that we're trying to match the use permit to the actual operation of the business. I don't believe that there's any injustice that would be done if we did that. Thank you.
Thank you, Commissioner Alburn. Yeah, I just want to make a few things clear here. First of all, it is the duty and responsibility and the authority of the Planning Commission to make decisions based upon the municipal code. In this case, we have a restricted use, a drinking place. It's incumbent upon the city, when they have a restricted use, to make sure that the use is fulfilling the conditions of that use. And in this case, the city acted with misdiscretion in this sort of cascade or continuing approval of permits to allow a full-line restaurant to develop there. But we, the Planning Commission, are not bound by those decisions, because what we are bound by is making decisions based upon the land use documents, municipal code, in this case, what is the definition of a drinking place and what is the definition of a full-line restaurant. We are not to be influenced by time, money, or uncertain decisions. That is for the courts to decide. So it's pretty clear that this business is operating as a full-line restaurant. And for us to pass Resolution 2 to expand to change the balance of the ancillary use of a drinking place, where the full-line restaurant becomes the main use and the drinking place becomes an ancillary use, that's a definition of a full-line restaurant. That is not the definition of a drinking place. So I think it's pretty clear here that we can't make that decision. I do want to say, I would never do anything that I believe would harm this business or this property owner. And I'm sure that they could go into court and they're going to argue that they have damages here, and that's for the court to decide. But within the context of our authority, the municipal code, what we're proposing here is not a taking. We're not taking this business operator's right away to operate exactly how they operate. We're not taking this property owner's right away to maximize the income from the use of their property. The property owner has acted in good faith, and I think the business owner has also acted in good faith. I really feel that most of the blame here lies with the city. And it is responsibility of the Planning Commission to correct those types of imbalances, and it is our responsibility to make decisions based upon what the land use law says. So having said that, I believe that really the only action that this Planning Commission take is with Resolution 1, where we need to require that we make a decision that the drinking place use permit has been abandoned and that a use permit needs to be applied for a full-line restaurant. And I would also encourage that there shouldn't be any cost to the business owner or the property owner with regards to this change, because I do feel that most of the responsibility lies with the city and the decisions that they've made, and the fact that they did not pay attention to this restrictive land use, and they even ignored conditions which they placed on previous building permit, you know, about the full-line kitchen, and allowed it to continue it to expand. So I'm going to make a motion that we accept Resolution 1. I'm still a little bit questioning about the language in there that the applicant, the business owner, and the business operator have to agree. I guess that's just implied, because obviously they will have to agree to pull the permit,
They will have
the
to
use
review.
permit, and they will agree to that at that time. So I think it's kind of overstating it, but it is part of the process of applying for a new use permit.
That would be the consent.
Excuse me,
Yes.
could you please explain then what the consequences are of this draft resolution? I don't quite understand. So, Resolution 1, which would be declaring that the use permit has been vacated, what happens next? Are you saying that the business owner then needs to apply for a new use permit?
Yes.
as a full-line restaurant.
That's the second part, the written consent.
Yeah, maybe we need to go through this to make sure that
I'd very much like us to
it's
be
gonna,
crystal clear, especially
It's clear.
on the part of the, both the business owner and the property owner, so that we have that
yeah,
crystal clear,
I think that's something we should do.
and that we can streamline
Yeah, so we have
as much as possible.
conditions here which are set forth. If I'm, these are the findings. The findings, the facts set forth in the recite, this is number one, set forth above are true and correct and are incorporated herein by reference. 2, find the proposed action by the commission is not a project under SEQA as defined in the Public Resources Code. I'm not going to go into that any further. 3, determine the drinking establishment SHUCKS Cocktail and Oyster Bar has been abandoned for more than 6 months in accordance with the Carmel Municipal Code. The code is stated based on the facts and the following findings. The use permit was adopted on December 8th, 1993. This is just establishing the history. Condition 2, finding 2 was that the sale and service of food shall be limited to the menu submitted. Permittee shall not authorize establishing a full kitchen. This was a condition of one of the previously issued permits. 3, condition 8, the use permit shall become void and no further force or effect upon termination, discontinuance of the use of any period time exceeding 6 months. 4, since 1993, building permits have been issued in this business, to this business for a commercial kitchen, including the installation of salamander, boiler, griddle, burners, fryer, pot burner. This was the expansion of the kitchen. 5, August 8, 2023, business license was issued with authorization, a use classified as a full-line restaurant as a primary use and a drinking place as an ancillary use. 6, for at least the last 6 months, SHUCKS has now operated as a drinking place establishment with the sale of limited food as approved by use permit 9345. 7, the uses of the property where the business is located are subject to the conditions of use permit 93-45. 8, the use permit may be amended upon application to the city is approved by the Planning Commission. 9, use permit 9345 has been amended since December 8, 1993. 10, the building permit does not amend, a building permit does not amend a use permit. 11, a business license does not amend a use permit. Further, the main findings of the resolution, number 4, amend the use permit number UP 9345 to convert the allowed use from a drinking place to a full-line restaurant, subject to the written consent of SHUCKS business owner and the property owner, and subject to a return to the Planning Commission with the proposed amendment to use permit 93-45 with appropriate findings. 5, if SHUCKS business owner and property owner submit to the city's written consent to the amendment to the use permit stated above 9345 to convert the allowed use from a drinking place to a full-line restaurant, then staff is directed to return to the Planning Commission with such amendment to the use permit 9345 with appropriate findings.
May I ask a question? Would we allow an opportunity for the owner to switch the business model?
Well, this resolution states that the drinking place use permit has been abandoned, and that an amendment to the original use permit, UP 93-45, would need to be made to make the primary use a full-line restaurant, which can have an ancillary use as serving alcohol. And that would come back to the planning commission for approval. That would be an application made by the business. Is it also required that the property owner make that application?
Property owner,
And
there's also,
property owner and the business owner would both have to make that application.
I have a question. Would it be amending the 1993 permit, or would it be a new use permit?
Yeah, I was curious about that.
That is.
It seems cleaner to me just to.
a new use permit.
A new use
Oh, a
permit.
new use permit.
Our code doesn't technically have an amendment section, like looking at it as a whole.
Well, and it seems like things have changed so much over time too, that it would be appropriate to have a current number on it, reflecting when this action.
Yeah, I would suggest we eliminate the language amendment.
Yeah.
And this resolution just confirms the abandonment and that the applicant should apply, the business owner and the business operator should, the property owner and the business operator should apply for a use permit for a full-line restaurant.
That, I think that addresses partly my question on number 4. Number 4 says amend use permit, UP 9345, subject to the written consent of the business owner and the property owner. What
Yeah,
if-
I'm
what if-
uncomfortable with the written
what
consent
if-
part.
I would
What-
take
I don't
out
know.
finding 4.
Given what we've heard, I would imagine they would opt to not consent. So is this the correct language for us to
Yeah,
have under
I don't
item
think it's
4, or should that be rewritten?
I don't think it's appropriate for this resolution. It's their decision whether they want to apply for the full-line restaurant use permit.
But they will need to apply for some permit if this permit is,
Right, or they can challenge this, they can appeal this decision to the city council, or they can decide that they want to file a lawsuit with the courts. That's my understanding. And those are all their rights,
of course.
you know.
And I think findings 4 and 5 should be deleted.
I didn't get that last part.
4 and 5 both should be deleted in this case.
The
The
last-
action really is that we're saying that use permit no
Is
longer,
abandoned.
and that they need to get a new use permit.
Okay, so then on the very first page on the bold, is it the desire of the commission to strike out the second part? Where
Where it says and amending use permit?
and amending?
Yeah.
Yes. So has been abandoned, strike out and amending use permit up until the finding that the planning commission action is not a project under secret.
Yes.
Okay.
Yes.
Okay, so basically we're striking all the amendment language out, and we're going to strike conditions 4
4 and 5.
4 and 5.
4 and 5, which are, those are main conditions, not the subcategory conditions of condition number 3,
Yeah, they're not findings on that, no.
findings. Okay, is that clear?
Yes, sir.
Agreed upon?
Yeah, and
Okay.
I'll second the motion, and with also that there are not fees charged for a new use permit for this use.
I think that, well, wouldn't that be part of the application for the use permit?
When it comes to us?
Yeah, that
I
they
guess
would.
that's true, although
then we
they
would-
probably have to pay money up front.
Well, it would
supposedly-
be refunded.
Yeah.
We can make that a condition, we can make that a condition of the approval if they decide to apply for that use permit.
Maybe just a quick point of clarification. The code allows the city council to waive or refund fees if fees are in excess of $1,000, which would be in this case. So perhaps entertaining instead of a condition of approval, but maybe a recommendation from the planning commission to the city council to waive a fee for a use permit?
But it won't be, it'll come back to us.
I think we can have this discussion when it comes back. I don't think right now this should be part of this motion. I think that's not part of this motion. The fee.
Agree.
So I have a question.
Yes.
If you pass this resolution without sections 4 and 5, what is your intent with respect to the operation of this business after this resolution is passed?
Our intent would be that the business can we could put in the motion, the business can operate under its current use permit until they apply for the new use permit.
Within a period of time? Yeah.
Within
With a time frame.
6 months. Unless the council wants to advise us on that condition.
It's up to the commission. I just raised it because, for the obvious reason that they're in business, and so if you wanted to give them 6 months to apply for a...
Well, I don't want to cause any harm to them, so what is your suggestion?
I think your suggestion is fine.
Okay.
I'll go with
All
that.
right. Okay,
So that would be number 4.
yes.
And I just asked the director, did you get the point that was being made by the chair on that?
Yes.
That they'd be able to operate under their existing use permit until,
For a period.
for a
not to
period
exceed.
of up to 6 months.
Unless a permit is obtained.
And the 6 months running from today?
Yes. Okay, any further discussion? Roll call, please.
So since you amended the resolution, I think the motion would be for the adoption of this resolution as amended by the commission.
All right, then I'll make the motion, we adopt the resolution as amended by the planning commission.
Second.
Roll call, please.
Commissioner Alborn?
Yes.
Commissioner Allen?
No.
Commissioner Karapetko?
Yes.
Commissioner Locke?
Yes.
And Chair LePage?
Yes, motion is carried.
Can we have a break?
Yeah, let's reconvene at 6:20. Oh, you were missing Aaron, okay. Can I get some more water from you? Thank you. Okay, we will reconvene. Can we have roll call, please?
Commissioner Albort?
Here.
Commissioner Allen? Here. Commissioner Petkov?
Here.
Commissioner Locke?
Here.
And Chair LePage.
Here. Okay, the next item on the public hearings tonight is item number 6. This is 2 use permits. Use permit 25178 and use permit 25303, and a design review, 25184. This is for Great Valley Holdings, Mama's Boy, consideration of use permit to allow a change of use to the front of a building from an office to a deli with no on-site cooking, retail shop, and use permit for change of use for rebuilding to a full-line restaurant, and then a track 2 for exterior modifications. Now, staff report, please.
Good evening, Commissioners. I just tried to edit the error on the title page that says February 14th, but we don't have a license on this laptop, so it's an error. Yes, I just had Valentine's Day spirit in my heart. I'm going to be brief with this as a forewarning. So background and project description, we'll start with Mama's Boy. The application was for a specialty food store, Mama's Boy. It would be a delicatessen at Dolores 2 Northeast of 5th. It's in the lower level of the western building of the site having 2 buildings on it, as you saw at the site visit today. The square footage listed in the plans for the lower level are 857 square feet. The existing use is an office space, and they're requesting a use permit for a specialty food store. I quoted from their business description they provided that Mama's Boy evokes the spirit of an idyllic seaside sandwich shop you might stumble upon in a Sicilian village, sun-washed, personal, joyful, and joyfully retro. As we discussed briefly in the site visit today, there was a proposal to have a red color for the trim and door that I added a condition of approval to the resolution to have that be a more natural earth tone to align with our commercial design guidelines. The commercial design guidelines don't go into much detail on the color palettes that are allowed in the commercial zones, but do specify that bright primary colors are discouraged. But I believe it is at your discretion if you believe that it would be an appropriate color for this site, so we can strike that special condition regarding the color if deemed appropriate. Besides that, the proposal as part of the design review would be to remove the bay windows at the front and to install flush windows, and then have a small seating area in front that is still on private property but adjacent to the sidewalk to allow customers that are getting sandwiches to eat some food in front of the store. Next, we'll be looking at MAMMONE, which is the proposed full-line restaurant in the east building of the site. This is a 2-story structure that has a connected unit. The upstairs and downstairs is all one contiguous unit. The total square footage for this building would be 2178 in its existing office space. Again, I quoted from their business description to give you a understanding of the atmosphere they're hoping to create here. MAMMONE is the older, more sophisticated sister to Mama's Boy, irreverent, layered, and effortlessly stylish. The space leans into deep tones like burgundy and olive with unexpected pops of orchid and apricot. Furnishing patterns and lighting combine to create the feeling of entering a beloved, slightly eccentric Italian home. Design elements shift naturally from bright lunches on the patio to intimate dinners indoors. So as you can see from the floor plan, there'll be dining space and a service bar on the north portion of the property. Dining in the south portion with the kitchen and dish area in the rear, and with patio seating in the center of the courtyard. As part of the design review, they're proposing to demolish the existing trash enclosure and shift it to the east, as well as align the patio space a little better to allow for the outdoor seating. Just a note, the property requested additional water from the city, from the commercial water bucket that was recently got from the pure water allocation. We had enough available, and so with the approval of this use permit, we would be allocating some of that water to this site for MAMMONE. I want to include the color palette here so you can see what they're hoping to achieve on site. For MAMMONE, they weren't proposing the same red for the trim and door. There is a color palette that includes some primary colors or brighter colors, but that wouldn't be reflected on the exterior for the doors and trims. The doors and trims would be a more muted earth tone that fits with the commercial design guidelines, so that's not a concern. On the right section of this slide, we show the upper floor plan, where there'd be some secondary prep area, employee lockers, dry storage, some additional more private dining, and a restroom. Some resolution changes. This is just a errata. This is a error on staff's part for moving a little too quick last Friday. As part of the authorization, there was reference to a different business in town that is not associated with this. I accidentally put PM instead of AM at one point. And then at the request of the applicant, we adjusted the hours to 9 a.m. instead of 11 a.m. They thought there's no immediate plans to have a breakfast, have it specifically tailored to breakfast, but as the code would not prohibit opening the business a little bit earlier, they figured aligning it with Mama's Boy, just in case for future plans, would be an appropriate course of action. Additionally, there's amendments to the to the number of seats. When I was writing the staff report, I was writing it based off of the original water permit application that they submitted to us, but there was an amendment to that in December that adjusted the numbers from 40 interior seats and therefore 20 exterior to 43 interior and 22 exterior. And this is all in their water permit that was filed with the Monterey Peninsula Water Management District and would be subject to them finalizing that permit as part of the building permit process. With that, staff recommends that the Planning Commission adopt the resolution attachment 1 with the revisions outlined in the previous slide, finding the project categorically exempt from CEQA, approving the use permit for Mama's Boy, approving the use permit for MAMMONE, and approving the design review for the building as a whole. If you have any questions, I'm here to answer them. Thank you.
Questions for staff? Any questions?
I only have one question, because this is unusual situation. I don't think we have discussed anything like that. So the Mama's Boy is not gonna have any cooking. It's only food that is packaged there, right? But the cooking will happen, if any cooking happens, it will happen in the building in the back, in the MAMMONE. Is that correct?
Yes, from the descriptions that were submitted to us, the Mama's Boy would just be a specialty food store, so you could buy food and drinks there and get pre-made food or pre-prepared foods from the delicatessen, or have sandwiches cold prepped there, I believe. There wouldn't be any cooking in Mama's Boy. It'd all be in MAMMONE and there are two separate businesses. From my understanding from the business proposals, MAMMONE, the facilities for MAMMONE wouldn't be used necessarily for prepping food for Mama's Boy, or if it was, it would be because they're by the shared owner, and so it may be prepping some sides or things of that nature. But it's not, there'd be two independently operating businesses.
Yeah, they should be kept separate, because Mama's Boy is not allowed to cook, and MAMMONE is not allowed to takeouts.
Well, right? MAMMONE could do takeout, but not as part of not as their primary business. If someone, I think, wants to take a doggy back home after a dinner, that's acceptable in all of our full-line restaurants. There's nothing, it just has to be fully contained. Part of the code requires that any to-go food be fully contained, except for frozen desserts when leaving a space. And yes, they are two separate. That's why we directed the applicants to file for two separate use permits, because they would be operating as two separate businesses with two separate requirements.
Okay, thank you.
Any more questions for staff? Yes.
Thank you. Could you speak again to the red color? Does that appear on the exterior?
For Mama's Boy, that's why
For either?
Not for MAMMONE, for Mama's Boy, there was a reference to the door and trim of the west buildings, the one that's facing the street, having that red color, which is why I added the condition of approval that they would, prior to building permit issuance for the design review work, that they would choose a different color for that trim that would be more aligned with the commercial design guidelines.
So do we have a rendering of what that might look like?
It's in this color palette. I know it's not perfect on the screen just because the colors can kind of change a little bit when they're thrown on display like this. But if you look at Mama's Boy, it's that red, the third from the left, on the right side of the slide under the Mama's Boy section here. And I can actually think it's a little bit larger here, so you can see that red there at the bottom.
A tomato red. All right, thank you.
Yes.
And then there's two, I think, very, very valid questions that came in through an email from Ms. Wilson. She says street parking is already a challenge for seniors, 2 to 3 hour regular parking and 3-day disabled parking. She says that with existing demand from Noir Restaurant and forthcoming demand from the Pasteur project, how many Dolores Street spaces are anticipated to be lost to residents due to the proposed project?
I don't have that information available. There has not been a traffic study that was done in association with this application.
I see. And do we have any parking requirements related to restaurants in town?
I don't have the code in front of me, but I believe that all commercial spaces are required to have each unit roughly one space per commercial use. I can pull up the code to look into that further for you. Thank you. We have a table. Okay, so it's for all commercial zoning districts and for all commercial retail or service uses, there is one space per 600 square feet of commercial floor area or per business shop, whichever is greater.
And do we have that satisfied in this project?
There is no proposed parking in association with this project. The site currently doesn't have any parking available for the existing commercial spaces.
I see. All right, thank you. And one last question, also from Ms. Wilson, on noise. Dolores between 5th and 4th is currently quiet with residences on either side. The proposed project, outdoor dining and drinking in the courtyard with an entrance and exit onto Dolores, may increase nighttime noise and perhaps disturb the quiet. Will this occur?
Part of the review of this application, there's an additional use regulation section of 1714 that requires a traffic study to show that you'll have less than a certain number of vehicle trips per day if you want to operate with your outside seating past 8 p.m. Instead of going for this traffic study, the applicant chose to go with an 8 o'clock closing time for MAMMONE. So that's reflected in their use permit and the conditions that they need to close at 8 p.m. That would be the closing time to accommodate that.
Perfect, thank you. All three of my questions have been satisfied.
Okay, any further questions for staff? Okay, at this time, I'd like to invite the applicant to come forward and make their presentation.
Good evening, commissioners, city staff, and my neighbors. Thank you for allowing me a few moments to speak before you. This moment is a long time coming. I have dreamed about creating Mama's Boy and MAMMONE for many years, meant as an homage to my family history and my very fond memories of growing up here on the Monterey Peninsula. My family, on my father's side, originally immigrated from Carlentini, a small village in the province of Siracusa in Sicily. Growing up surrounded by packs of cousins and always a busy kitchen helmed by talented nanas, aunties, and my mother, it makes perfect sense that I would end up seeking out that nostalgia as a restaurant professional. I could have chosen a less demanding career path, but the emotion you feel in a well-operated restaurant has a sense of magic about it, like nothing else. I love caring for people in this way and intend for these new concepts to be a place where we feed not just the belly, but also the heart and the head. My wife and I are local since birth, and have lived in Carmel-by-the-Sea for the past 8 years. With our 3 young children, we are so grateful to be a part of this community and take great joy in operating a thriving restaurant called Stationary, which we gear toward local families specifically. We source from local farms and ranches and pride ourselves on creating an ever-changing menu that celebrates the bounty that we have at our fingertips. We will continue to hold these very high standards and philosophies at our new establishments. In advance of changing the use permit for our property and in an effort to open the space to the public, we actually created a business for the business. For several months, we opened the doors to Say Yes Mama, which is a fun reference to a refrain we encourage our children to repeat to make sure that they're listening to their mama. The store itself was a retail concept we did in collaboration with many of our talented friends here locally. If you had a chance to visit, you would have observed us engaged in lively conversation with our guests, wherein we asked for a genuine feedback on the hospitality concepts that are to come. I learned a long time ago that clarity and communication is the key to a good relationship. Therefore, we sought to assuage any concerns our neighbors might have. Thankfully, the feedback was primarily positive, and some folks even gave us good ideas for what they would be excited to see on our offerings. There were only 2 gentle concerns we received, and they were as follows. In regard to the ongoing parking difficulties that we are all familiar with, and in regard to potential late-night noise issues. To the first concern, we respond that as Carmelites, one of our very favorite parts of being local is the ability to walk everywhere from our home. And what a happy moment it is when we're walking into town, into work, or to do shopping, and see a fellow local to have a smile and a chat. In fact, now that our eldest is 8, we even send him to Bruno's and to Nielsen's on foot to pick up groceries. And when he and our daughter hop off the school bus at Carmel Youth Center, they can walk right over to our restaurant. Every day, people arrive at Stationary, having just walked into town with their dogs. As far as our staff are concerned, we encourage carpooling, public transport, and the use of the Vista Lobos parking lot, all of which they participate in. As for the out-of-town guests, if they've already parked at a hotel property, they can enjoy walking about town. We know quite a few hoteliers, and they say their guests park once and then enjoy the rest of their time on foot. As far as the second item, as the parents of young children, we decidedly do not want to operate a late-night establishment. We're too tired to do so. Now that's a bit tongue-in-cheek, but practically speaking, the physical setup of our space is ideal to contain noise. Whereas the deli will be grab and go with only 4 seats up front, 2 two-top tables in front of the windows. The main restaurant is set back from the street, behind the first building, which will contain the deli. And it's surrounded, it's set back from the street, and it's surrounded by buildings on 3 sides. So 2 of them are ours. The third is a wall to the hotel with no windows in it. These 3 sides serve to contain any noise that might be disruptive to our neighbors. Further, the 4th side of the patio looks out at the post office parking lot, and therefore won't be disruptive in that direction either. Really, it is ideally situated for noise abatement. I should also like to mention that even before signing the lease, we made the effort to tour various city officials through the property to explain our project goals. They included, but were not limited to, our acting city manager, the city planner, building inspector, and fire marshal. They were all very gracious in offering their counsel. I stated then, and I will mention again now, that we intend to be good dance partners with the city, and we are eager to be communicative. Additionally, I should mention Jacob's many hours in answering our questions, doing research, and correspondence guiding us through this very complicated process. We made sure to adhere to all code requirements, made sure that our design considerations were appropriate in the context of this neighborhood, and that the concept itself acts as a very positive force to support the spirit and charm of Carmel-by-the-Sea. Before you now, I will state that you will find us forthcoming and good faith actors. We welcome any feedback that you might have, and we will do our best to make sure that this process continues to go smoothly. We are thrilled at the prospect of offering Mama's Boy and MAMMONE to the village, and I assure you that we will make it a heartfelt favorite of our residents. Thank you for your time and your efforts on behalf of the community and your consideration.
Thank you. Okay, any members of the public like to address the Planning Commission regarding this application?
Good evening. My name is Carrie Tice, and I live directly about a block from this proposed location. So I'm here to support this great idea. For those of you that remember the Mediterranean market, I think this is going to be a smaller version of that. And it's something that, as a longtime resident, we have missed the Mediterranean market. So going into a place that has that smell of Italian meats and cheeses, I think that Anthony and his wife have really put a lot of thoughtful pride into what they're doing. They're also proven. They have stationery. It's a well-run business, it's consistent, and it's very considerate of what Carmel's about. So I'm here to say that as a neighbor, I would love to be able to walk down to this restaurant and deli. Thank you.
Thank you for your comments, Carrie. Any other members of the public like to address us? Adam, come on up.
Good evening, Chair LePage, members of the commission. I'm Adam Jesselnick. I'm here tonight just to support a fellow business owner in the village. I think that what Anthony and Alyssa have put together in this proposal is something that our town really needs. You can tell that it's been exceptionally thought through with a lot of consideration given to their neighbors and to the needs of our town. I'd also just like to mention that over the last year, we've lost a number of longstanding local favorites, restaurants, and so this will definitely fill a void. So I just would urge you to support their proposal and bring this great new restaurant to the village. Thank you.
Thanks for your comments, Adam. We see we have a hand up online. Monique, would you like to unmute yourself?
Hi there, are you able to hear me?
Yes, we can. Go ahead.
Okay, thank you. So my name's Monique Black. I actually live next door to this project, and my daughter's room looks into it, actually. We also operate the restaurant that's just catty corner to it, Chez Noir. So in some ways, I feel like we're uniquely suited to speak to it, and we're very happy that it's happening, and we're really happy to support it. Anthony and Alyssa have been remarkably supportive of us and of other business owners in the community. Anthony very directly through his previous leadership role, through the Restaurant Improvements District, but also more anecdotally, just through genuine and continuous support of us and others. He often says, rising tide lifts all boats, and I'm very excited as a neighbor to have this business here for us, for my family to enjoy, and also another wonderful place for me to recommend to my own guests. I think it's important to have a variety of different offerings from people who are also residents in this community. And it's hard for me to think of anyone who's more committed to Carmel than Anthony and Alyssa. And so I'm very happy to support them in this project and look forward to being their guest.
Thank you for your comments. Okay, I don't see any other hands coming up online. Nobody coming forward, so I'm going to close the public comments, open it up to the commission for discussion. Commissioner Auburn, you want to begin?
Yes, thank you, Chair. We had a chance to tour the property and see both locations plus the patio. I, for one, am thrilled to see more outdoor seating in Carmel. I wish we could have more of it. I recognize there were some changes to the numbers of the seats, but I presume that that the applicant is understanding of what that new seating arrangement will be. The menus look awesome, so I would be very much in support of approving all of the both use permits and also the design review. Thank you.
Thank you. Commissioner Allen.
Yeah, I feel the same.
Okay. Commissioner Locke
Me too.
and Commissioner Carapetca.
Yeah, a couple of comments. So it is interesting when you take a property that was used as a office, legal office, I guess, and convert it into a restaurant, there must be some checklist what needs to change in the building to make it a restaurant, right?
I believe that'll be part of the building permit application. They'll review for change of occupancy and any upgrades that are needed in association with the change.
Yeah, because, you know, when you build kitchen, for example, you need additional power, new panel, electrical panel, for example, you know, for this additional appliances, something that is not required in the office usually. So I assume that this is all going to be taken care of. We don't need to think about it, right?
That's my understanding, yes. If there is anything that would contradict what was approved in the design review, they would need to come back to planning to get approval for that. And depending on the scope of that work, it would need to be heard in front of the planning commission again.
Okay, so two concerns. One is emergency exits. If something happens in this restaurant and there are quite a lot of tables in there, will there be emergency exit maybe to the parking lot or some other way to get out instead of going through Mama's Boy?
Currently, there is no egress to the parking lot, but again, that would be something that building would review as part of that. I guess fire would review as part of that to make sure that they were compliant with any safety standards. And there is, I believe, as we got there today, there's a path that goes along the side of Mama's Boy that takes you back to MAMMONE, so you don't need to actually go through Mama's Boy itself, but you do have to exit on that street.
Okay, thank you. And then the parking issue, I'm trying to understand if the fact that the property is next to the parking lot for the post office, if that is a benefit, because the post office is closed in the evening, the restaurant is open, can that parking lot be used in any way, shared between the post office and the business? I'm very concerned about not having enough parking. I mean, I'm all for walking, and I do walk in the city, but I know a lot of people cannot walk everywhere, so you still need to have some accommodation for people who need to park at least for a short period of time. And also delivering supplies, I would love to understand the logistics of delivering supplies to the restaurant. Is there a back entrance or some other way to get in?
Based off what's in the plans, there isn't a back entrance for the delivery of supplies, but I would let the applicant speak more to logistics on how they get their produce and any materials they need for the restaurant to this location.
Okay, these are my comments.
Did you want the applicant to speak to that?
Yeah, that would be nice, yeah, thank you.
You want to come up, Anthony? Thank you.
Me again. No, I'm happy for your question. So it was about logistics specifically. Yeah, so we actually have experience with this at our current restaurant at Stationary. There's no back entrance to Stationary. So, and thankfully we're not one of the restaurants that has the larger vehicles that deliver. I mean, they're commercial vehicles, but they're not like the big guys, based off of the way that we source. So what happens every day when we get deliveries is the delivery vehicle pulls up in front. Typically it's going to be earlier in the morning, not crazy early, but earlier, such that traffic patterns won't be adversely affected. They make the delivery. We're a fairly small restaurant, so the deliveries are not particularly large, and they're in and out within a matter of minutes. It's pretty quick.
So the everything you need for the kitchen will be brought in through the front entrance?
Yes, sir. Mm-hmm.
Okay. Okay. I think that is, in the parking lot, do you have any insights on sharing the parking lot with the post office? What happens with the parking lot at night or in the evening?
Yes, so I know that the parking lot in the evenings, once the post office is closed, all the residents or people who are patronizing businesses will use those parking spaces. Yes.
So there's no restriction using the parking? Okay.
No, it's pretty convenient.
Okay, thank you.
Yes, sir. Any other questions, Juan?
I think we're good. Okay, thank you.
Okay, thank you.
Okay, That concludes your comments, I assume? Okay, all right. Yeah, I'm fully in support of this application. We have an experienced restaurateur opening up a couple of really nice businesses. I love delis. I'll be there first, and then the restaurant. And I am looking forward to kind of a nouveau Mediterranean market. That would really be nice. I remember those days. Loved Med Market. Although you gotta have a really crabby guy behind the making the sandwiches. They had this guy at Med Market. He never smiled. Very short-tempered. Okay. Anyway, we have a resolution. I think pretty standard conditions of approval.
Can I
Yes, go ahead.
just really quickly? And I know your questions have been satisfied, but I just wanted to verify for myself, just to try and get some more information to, so I'm in Google Street View right now, looking at the parking lot for the post office, and it specifies 10-minute parking only from 8 a.m. to 5 p.m. So after 5 p.m., that parking lot would be open to the public.
Yeah.
Is there a special condition on the color for the door? I know you mentioned.
Yeah, it's conditioned.
I didn't see it.
What is that?
It's. Special condition number 23.
23, okay, thank you.
There's a T missing from paint there, so it says
Yeah,
Mama's Boy
I
Paint.
did
So
see that's right.
we'll add that to the errata slide for
Yeah.
fixes.
Jake, on number 1, is that?
That's the, if we go back to the errata slide, that if you're talking the authorization,
Yeah.
where it references a restaurant that's not in association
Oh,
with this.
okay,
That's
so-
that's part of the errata. So with the adoption of this resolution, with the amendments from that slide, that line will be stricken from
Okay,
the resolution.
okay, I was like, did
That was-
yeah, okay.
Unfortunately, purely staff error, and I can put blame onto no one else but myself.
Might be.
Yeah, okay, so we're omitting condition of approval number 1? Or modifying?
Let me pull up the slideshow again. There is going to be, I included the strike-throughs here.
Just so we are clear on this.
Can you ask IT to switch screen? Just one moment. The slide will come back up, but it shows, I've showed the proposed edits to the resolution that would be changed in the resolution as part of the adoption of it. And that includes the strike through of any references in the authorization to other businesses. It would include fixing of the, there we go. So it strikes through, I thought that that line got deleted as part of the editing process, but it did not. So again, staff error. And then changing the 11 to 9, the PM to AM, the 40 to 43, and the 20 to 22. And then I'm gonna add to this list is special condition number 23 will now read Mama's Boy Paint and not, instead of Mama's Boy Pain. Because that is a
Okay.
typo.
All right, so I'll make a motion, we accept the resolution as per staff with the corrections.
Can I ask one other question? I'm sorry.
Go ahead.
No problem.
Let me second the motion and then, but the seating for the restaurant, and this is just a proposal for you guys. I talked with Jake earlier today, and it appears that there actually may be more water available on site than was calculated in the plans. And I know you've got this odd number of interior seats, and so I'm going to actually propose that you make it an even number and go with, what is it, 44 interior. And then that would allow 22 exterior seats, which also may reduce how much water is needed from the city's allocation. So I'm assuming that I'm correct on my calculations, but yeah.
And we do too.
Yeah, okay, thank you.
Okay, so we're gonna amend the seating?
Yes, I think, I believe there's an earlier condition in the use permit that states that the authorization of this use permit
does,
the
yeah.
approval of this use permit doesn't authorize additional water. That would be part of the water permit itself, so we can do the 44 and 22. And then just
then-
make sure that's reflected in the water permit.
Yeah, and any additional water would come from the city's, any additional needed, but I think it's less than what was proposed.
Per our conversation, I think that that's correct, and if not, there is still commercial water available that would be able to accommodate the additional seed.
Yes.
Okay, my motion is amended.
I second your motion. Okay.
Okay. Any
With
further-
those changes.
Yes. Any further discussion? Hearing none, roll call, please.
Commissioner Alport?
Yes.
Commissioner Allen?
Yes.
Commissioner Karapetko?
Yes.
Commissioner Locke?
Yes.
And Chair LePage?
Yes, motion is carried. Thank you. Okay, that brings us to item number 7 on the public hearing. This is a design study, 25139. This is the Kearshire Property Investments, consideration of a concept design study, demolition of an existing home, and the construction of a new home. We have the staff report, please.
Thank you, Chair. Okay, so this subject site is located at Monteverde Street, 4 southwest of 3rd Avenue. It's a 10,000 square foot lot currently developed with a 1,440 square foot residence. All site improvements are proposed to be demolished, and the applicant is proposing to construct a 3,292 square foot project that includes a 449 square foot attached garage, as well as a 800 square foot detached ADU is also shown on the plans. So at the December 11th, 2025 hearing, the Planning Commission did consider the project. The staff report at that hearing identified issues with concept finding number 2, 3, 4, and 6. The commission deliberation identified additional issues, including this number and size of doors, the glazing and the number of curtain walls, the compound-like appearance, the size of the skylight proposed, impacts to the proposed clear story windows, the use of, or suggested the use of natural features to achieve privacy, the driveway material, the amount of exterior lighting, and the general building form. The item was continued with the direction to the applicant to then modify the project. Looks like a duplicate slide there. So today's consideration, the applicant has revised the project, and the commission should consider, do the revised plans adequately address the concerns of the commission at the previous hearing, as this is a continuation of that hearing. Additional considerations are, do the revised plans meet the findings for concept acceptance, and are the revised plans consistent with the residential design guidelines? So this presentation is largely a duplicate of the staff report. The staff report was a lot of images, and this presentation is largely the same. So I apologize for any repetitiveness. So the applicant stated that the large skylights have been reduced to 3 smaller skylights. So as illustrated, the applicant has replaced the single 9 foot 2 inch by 14 foot skylight with 3 9 foot 2 inch by 4 foot 8 inch skylights. It is noteworthy that the sum of the 3 skylights is the same square footage as the singular skylight. The applicant has also stated that the door header heights have been reduced from 10 feet to 8 feet and below. So you can see this change. Here, this was the initial proposal with the door, which reached the top of the building wall. This is a glass door, and then this was a solid wood door, so the doors have been reduced. although the glazing is largely the same. This is the east or the front elevation, similar treatment here. Oh, I apologize. So on these figures, the top is the existing and the bottom is the proposed, or the revised. So this is the courtyard elevation, or the south, so the interior of the site. This is the north elevation, or the side closest to the nearest property, or adjacent property. So similar treatment with those door heights coming down. And then on the west or the rear, there were no doors. The applicant has also noted that the finished floor elevation has been raised 9 inches. So that's illustrated here. Effectively, the 9-inch raise is just shifting the entire building up 9 inches. So while the finished floor elevation was raised 9 inches, the roof was also raised 9 inches. According to the applicant, the front elevation was adjusted so a horizontal band now extends around the garage. So that's illustrated on the screen there. The front stone wall was reduced and a fence was added to create a more woodsy feel. That's as described by the applicant. So on the left side of the slide, as you face the subject property, the front wall has been changed from a stone wall to a cedar fence. And then also some modification was made to the front entry gate. So now that height is in line instead of dipping down adjacent to the wall. The applicant has stated that the stone cladding has been reduced on the building facade and horizontal cladding mimicking wood has been added to create a more mid-century feel. So this is the front elevation, substantially similar between the two, but we do have a new horizontal header located above the garage door. So that's the front elevation. Again, on the courtyard elevation, there has been some changes made. There's a new wood return located at this rear corner of the building. This is the north elevation, or the side. So there were some fenestration changes which added wood to this building element. And then this is a storage room projection that's attached to the garage that was relocated adjacent to this other wood element on the residence. And then at the rear of the building, there was a stone element added that did not previously exist. And then the rear of the building, there were significant portions of stone that have now been replaced with wood siding. In respect to the lighting plan, the applicant stated that architectural lights have been reduced to what is necessary for building code, plus a few extra lights in the patio. The applicant also noted that landscape lighting will be reduced in the next submittal because that will be provided by a consultant. So staff notes that there's not been any change to the total number of light fixtures proposed, but the style of fixtures and general locations have been slightly modified. And as noted, there's been no change to the total number of fixtures, and then that the landscape lighting plan has not been revised yet or updated. The applicant noted that the site coverage has been rearranged and that the drivable grass has been removed. So the drivable grass driveway has been replaced with pavers, and while staff's concern was initially that the drivable grass should be included in the site coverage calculation, due to the construction method and assembly of the subject features, the commission was less supportive of the material altogether. So should the commission elect to accept the concept design study, staff recommends the following conditions of approval be included in any forthcoming resolution for concept acceptance, as these were discussed in detail at the previous hearing. The commission is not limited to these conditions. However, these were included in the staff report for the previous hearing or were included as standard, or are standard requirements. And just as reference, these are your findings for concept acceptance. So with that, staff recommends the Planning Commission consider the project and provide direction to staff and the applicant accordingly. Recommended options are to motion to adopt a resolution of intent to accept the concept design study with conditions of approval and direction to the applicant as appropriate, or to motion to continue the concept design study with the direction to the applicant as appropriate. And that concludes my presentation. Happy to answer any questions.
Questions for staff? Questions? Mr. Albert, question?
Yes, thank you, Chair. Mr. Court, the wall that is along the front of the property. Yes, thank you. So this, the previous design was all stone and now with a gate at what is to our far left. The new proposal is partial stone, partial wood, also with the gate, and then an additional return of fencing. Can you please remind me, when we have walls and fences in the front part of a property, for the design guidelines, what is the recommended height?
So the zoning code allows for, within the front setback, which this wall is outside of, a fence is 4 feet, a wall is 3 feet. So this wall is removed from the front setback. In that case, the wall, there is no prescribed height limit once you're outside of the front setback. Excuse me, I might be mistaken. So within the side setbacks, then a fence and a wall could be up to 6 feet. The Planning Commission can authorize taller fences and walls. However, the design guidelines, which is, then we're moving into discretionary, so that's from a zoning perspective. When you have a fence visible from the street along the front of the property line, then we're getting into discretionary territory where it says you should be able to see into the property. So this is something we discussed at the last hearing, where the codes and ordinance prescribe maximum and minimum height, or maximum and minimum limits, and those establish the range that you have, but they aren't effectively guaranteed. And through your discretionary review and looking for compliance with those design guidelines, they might be altered.
But if the guideline is that we should be able to see through to the property, based on the way that this proposal is cited on the land, it seems as though we actually are seeing through quite a bit through the front setback. Would you think that that's a true statement?
I can pull up the design guidelines and we can evaluate that closer.
I don't know that it's necessary. Let me see what my other commissioners think. Thank you.
Hey, Evan, can you pull up the door schedule?
Yeah, our little iPads are not loading the plan.
But yeah, they keep crashing.
I think it's a pretty large
Yeah.
plan set. Yeah, I'll get the actual plan set up on the computer.
It won't even switch. Oh, there we go. I got it to switch. Okay.
While you're doing that, I have another question on this, and that is, it appears that the new proposal actually has the fence closer to the street, just based on the number of trees and location of trees and how close that is.
And I'm sorry, Commissioner Allen, you said you wanted the door schedule?
Yeah, that'd be great. Thank you.
It might be actually easier to look at the illustrative schedule.
Yeah. Well, they went.
Oh,
from-
actually, no, it's
yeah,
not. They don't have
I mean,
it.
the schedule's fine, but they
Yeah.
went from like 10 to 8. It looks like. Thank you.
Thank you.
Oh, and I'm sorry,
Did you-
Commissioner Locke,
Did you want the door height?
I found yeah, they're listed here.
Yeah.
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 They went from like 10 to 8.
Yeah, well, they go from 7, 8 to 8 now, I think.
Yeah, I guess in the last review, they were at.
But
10.
8 is now the highest that
close
I
to
see.
10.
Yeah, right.
And Commissioner Locke had a question about the,
Oh,
I don't know if it was
yeah.
a question, but a comment about this, the location of the
That's the
wall.
garage door is a little higher, but. Okay, we're good?
Yeah. Are you looking at the fence?
I'm going to attempt to pull it up.
The fence, my understanding, the fence is back 15 feet. You're looking for the setback?
Correct.
It's 15 feet.
It's dimensioned at 15 feet, or actually a little bit, maybe within, maybe a couple inches back behind 15 feet. So it's just outside of the front setback.
Yeah, it's not in the front yard setback. Okay? You have your questions answered? All right, I want to invite the applicant or the applicant's architect to come up and make their presentation.
Good evening. My name is Eric Miller. I'm the architect on the project. And I want to talk about a little bit about what we did relative to the design, and we talked about this last time. This is a pretty rare opportunity to take a very large lot, which is 10,000 feet. And it's a really nicely wooded lot. The trees are beautiful. And the whole idea here is we decided not to build a two-story house and really wanted to make a very de minimis one-story house that was subordinate to the trees and the forest setting. So that was the design concept. And do you have my PowerPoint? Next slide. So one of the things that the commission was concerned about was some of the boxy feeling elements at the garage and some of the parapet areas. And because our design goal or design language is we want regional modern or mid-century modern design, we actually pulled the fascia straight across and no longer have a boxy element in the front. And I think it's very much consistent with the mid-century house that's two houses to the north. So if you look at the lower slide, you see the fascia. And as staff pointed out earlier, it really gives much more of a horizontal feeling to the house. And we also reduced the stone in the front. We talked about it earlier where there's more of a wooden fence and a stone element there. And, you know, relative to the location of that fence, there's quite a nice distance between the street and the property line that the city owns. And then beyond that, we're 15 feet 4 inches further back for our fence. So we think it's consistent with design guidelines because it's so far back from the street, and we're trying to get layered landscaping from the city median to our property while maintaining all the trees in a forest-like setting. We also softened the elevations and added a feeling of mid-century modernism with some more wood, as staff pointed out. The west side has significantly more wood, and we think it was a nice addition to the design. Can you go to the next one? So with regard to glass, so the skylight, Planning Commission was concerned with the size of the skylight. And, you know, we did reduce the glass in the skylight by having 3 units molded together. So it slightly reduced the amount of glass, but remember that the glass gets, at nighttime, there's a shade that automatically closes, so there's no dark sky effect. But during the daytime, it really makes a difference in that house because it brings light deep into the house and where the living room and kitchen are, dining room. So we hope we can keep it, but we are willing to reduce it if Planning Commission feels strongly about it. Maybe you could tell me 10% or 20%, something like that. We'd like to keep it because we don't think it affects anyone else. And especially since I don't think any other houses will see anything from the east side because there's so many trees, and we were out at the site today, and I think it was well demonstrated then. So also we reduced the doors. So the entry door now is 7 feet 6 and is a wooden door at 7 feet 6 with a transom above it. And then the courtyard doors are 7 feet 9. The 8-foot doors you're talking about are interior doors. So I think there might be one on the garage that's 8 feet, but so the courtyard doors are 7 feet 9. And we did reduce the clear story windows on the west side, as staff pointed out earlier. So can you go to the next slide? Relative to the site, the exterior lighting is the minimum amount of lighting we can have. By uniform building code, each door has to have a light. So we put lights around the perimeter of the building. We're happy to, at the next meeting, talk about the reduction of landscape lighting. But I don't think I can reduce the lighting on the house any further. The first application package had more lighting. We reduced it, and so I don't think we can take any more out. We also reduced the cut. Staff pointed out earlier that we before we were 8 inches deeper for the cut, and we think that raising it the 8 inches is reasonable. It makes less of a cut fill issue. But also the reason I would like it to be 8 inches higher is because when you're tall and you're looking at that site, I can almost see the roof. It's so low. So 8 inches higher means that a tall person like me can't see the roof because we don't want to see the roof because it's going to be a flat roof, or we'd like it to be a flat roof. And, I think it's better just a little bit higher. And if you look at this house, it's so much lower than the house to the north of that. One's a 2-story and one's a 1-story. And then the house to the south is much lower. So, is taller. So this is really the lowest house. And I thought it was getting pushed down a little bit too much, and I thought less grading would be a positive thing. We removed the drivable grass, as staff pointed out, and we think we're fine with that. So next slide, please. So you can see how really low that house sits on that site. We had some design guideline. I think we're consistent with that because we all know that, we want human scale. We want innovative design in a forest setting, privacy, sunlight, shared views, human scale. I think we achieve all that with a low profile of the massing. And I also feel like the trees are all maintained, and I think we're we're developing a mid-century modern feeling to this with that horizontal fascia. If we go to the next slide. So next slide. Next slide. Okay, so here's the location of the fence. The red line is the property line. So the existing plan shows a 6-foot fence right on the property line all the way across. So you can see how much space is between the property and the street. So that's a significant amount of space. It's probably 22 feet. And then if you look at where we're moving the fence, so it's 15 feet 4 inches. That's the new fence. And so we think it's 5 feet 6 high. So we think that you're going to get such a beautiful layering of landscape. It'll really feel like it's more generous than most houses around it. In fact, across the street, all the houses have 6-foot fences on the property line. So many of them do. So I think it's going to feel like a park-like setting that's subordinate to the trees around it. Can we go to the next slide? You can see how we carefully saved all the trees. Well, most of them. And you see the front yard where the ADU is, there's that oak tree right there. That's a raised bed, so we're not changing the natural grade of that tree. And all the other trees in, I'm going to quote unquote, park-like setting are really adding the layers of interest to the site. And that's the whole exercise we're going through here, is for this to feel like a house in a forest instead of trees around a house. Next slide, please. So you can see this is, if you look at the site plan, if you stand where we stood today and look north, you really see no houses at all. Next slide. So this is looking to the east, and it's the same condition with no houses visible. And then next slide. So that's the southeast view. Again, you really see nothing. There's a roof in this slide. And then next slide. So there's the south. So this lot just naturally is so private, and I think it's a real opportunity for us to do something other than a 2-story house. So we've been working hard to maintain it as more of a forested lot. Next slide, please. So this is a video showing the house there with a pin on it. I don't know if you can run the video. I think. Yeah, so the house has that yellow pin. You can see the trees. And so you can see that it's so well, protected from any other views anywhere around the site. And you can see how much higher the other houses will be compared to the one we're proposing. You can see the mid-century modern house on the left to the north. So next slide, please. Okay, thank you. Any questions?
Questions for Eric? Good.
Thank you. Because I'm still pretty new at this, the skylights, and they have some form of automatic screening.
Mm-hmm.
How does that work?
So it has a photovoltaic cell. So when the sun goes down and there's no light available, the shades automatically close. And that's why I think that having a three separate panels for that skylight would be better, because then I can have a track on the mullions of those panels, and I think it would be more reliable. But in the daytime when they're open, the only person that would benefit is us, because that's a lot of light deep in the house. Also, I think based on the video I just showed about the privacy in that house, even if shading failed, I don't think you would see it because it's just so hidden behind those trees.
Thank you. And is that the photovoltaic cell, is that hardwired?
Yeah.
And then could you speak just briefly, I know there have been comments about the clerestory windows and the neighbor to the west, is that correct? And you made some adjustments?
We did. We took one out completely and just put a standard window in. We kept the one in the master bedroom, but that's further north on the lot. Remember the day we all stood on the fence and that's that old tree stump there?
Yes.
That was the yard. So we took that window out completely. And the only one we kept was the one in the master bedroom.
Thank you.
Thank you.
Okay, thank you.
Thank you.
Okay, are there any members of the public that would like to address us about this application? I don't see anybody in the chamber. Any hands up, Shelby?
No, sir.
Okay, I'm going to close the public comments, bring it back to the commission for discussion. Commissioner Petkoff, you'd like to begin?
I think all the comments we made last time were taken into consideration and the changes were made in the project, so I cannot see anything that was missed. We discussed the size of the windows, they were reduced. We discussed the type of front fence that was changed. I think the overall improvement of the project is visible. Yeah, I don't have any additional comments. The only curious thing I noticed is that there's no garage, there's no door between the garage and the living room, so I'm not sure exactly if that is a new design concept. Usually you do want to have a door to walk from the garage into your house, but you know, maybe people don't need that. So, yeah, no further comments. I think the changes are very positive.
Okay, Commissioner Locke, your comments, please?
Sure. I think that, yes, there were definitely some changes that were made. Raising the building definitely is a plus for the trees. I am still concerned about the skylight, and I think that the direction that was given, or at least my recollection, was that our standard approval of skylights are usually 2x3 or 3x4. And as you've said, granted, you may have split it up into 3, but it's still substantially the same big, huge skylight. So I have a concern about that. I'm also concerned about the number of exterior lights. I realize that you've said that you're meeting code, but you also mentioned that there's what's necessary to safely light the covered patio. And so I know I saw some lights up on the ceiling area. That's a concern to me because we don't allow other people to do exterior lighting like that for their outdoor areas. And so, and given the fact that this home has a great deal of glass, which means there's going to be a lot of interior light flowing to the outdoors, I really don't think you need a lot of exterior lighting. And that goes also to what is not covered in this, which is landscape lighting. And I would like to, I couldn't pull up the plan, so I can't see what the landscape proposal was, but that should absolutely be minimal in this case, because again, I still have a concern that there may be light impacts up the hill. So those are my comments.
Commissioner Allen, your comments?
Yeah, it looks like he was able to address all of the concerns that I was not at the meeting in December. So it looks like he was able to address all of the concerns. I do share some of the concerns that Commissioner Locke just shared around outdoor lighting and the size of the skylight.
Commissioner Alburn?
Ditto. The difference in the size of the skylights we ordinarily approve and the size of these skylights gives me pause. That said, I do understand the reasoning behind the larger skylight in this particular project and the automatic closure based on a shade. So I'm less concerned than I was. I'm pleased that the clerestory window seems to have addressed the concern for light that would spill to a neighboring property. I'm also concerned about the exterior lighting plan, but I know that that was, I believe, one of the conditions of approval that Mr. Court had included, as well as the site coverage and making sure that that site coverage is in conformance with the city's guidelines. Other than that, I'm absolutely good with the changes and that have been made, and grateful that that they were made. Thank you.
Yeah, I think Eric he listened to us, he made a lot of changes, I think it looks better. It looks more like a mid-century modern. I mean, I think some of the exercise you did on the other one was interesting in terms of juxtapositioning of massing, but this is more true to a mid-century modern. The thing I really compliment you on is the way that you don't have a fence on the property line. You've got this stepping and tiered, setup, and that's really something that the guidelines really encourage, and we don't see it a lot. And it really contributes and connects with the history of Carmel, how it developed. And you can have a unique situation here because you've got a big lot, and it really is going to, I think, add a lot of really beautiful tiering of the landscaping, and the building is very subordinate to the landscaping as a consequence of that. I don't have a problem with the skylight. The issue with skylights typically is night sky, and the shade takes care of that. The other one is seeing it from the street. And I think Eric was really showed his just observance as an architect that just by raising it 8 or 9 inches, then you don't look at the roof, which I agree is you don't want to see that roof surface. What you want to see at this house is these strong horizontal lines. And so not seeing the roof, I think, is really key to this design. And before you just had it down too low, but you realize that, and I think that is. I really compliment you on that. So I don't think the skylight is going to, it addresses the night sky, and you're not going to see it. That's the main thing. You're not going to see the whole roof, which is nice. So as far as the lighting, most of the lighting is egress lighting by the doors. So the only lights that I see that are not egress are the ones in the overhang, and then there's 2 on the fence at the courtyard. Is that correct?
That's correct.
Yeah. So, and they're all down lights. So I'm not that concerned about it. What we don't want light projecting out into the street and washing out the the night sky and the darkness of our neighborhoods, which is really a historical characteristic of the neighborhoods. So I think this is pretty minimal lighting. It's all screened. You can't see it. So having said that, I don't have any other compliments or any comments on it other than to compliment the architect. I think he really took an interesting concept that was going in the right way and just made it better. So we have a resolution which has as conditions of concept acceptance, we just have the volume study. Number 1, the landscape plan, submittal requirements, schedule final detailing review, applicant shall work with staff to revise plan set to include requisite information necessary for scheduling final details. Unless you want to add anything?
No, I'm good.
Okay, I make a motion that we accept the resolution as presented by staff to approve.
I'll second it.
Oh, great.
Any further discussion?
I just have a
Go ahead.
point of clarification. There was no resolution. It was I apologize.
It's not a resolution?
No. It was a motion to.
For the intent?
Motion to
accept the
adopt
design.
a resolution of intent to accept. So
Accept the design,
we would come
okay.
back with a formal resolution.
All right, okay,
Oh,
Okay.
And then
Was there a reason for that? Do we normally have a, is that, that's
we didn't have one prepared at the first hearing, because we're seeking direction. And then the question was, were the plans adequately addressed?
Okay. So we have an intent, so the correct title,
We could, the director just made a suggestion. We could also come back. You can motion to have the, would it still be a resolution? We could intend to accept and then come back with a combined concept and final.
Yes?
okay,
I do recommend including the conditions within that motion, just so we take care of those things before we schedule for final details hearing.
all right, well, I'll amend my motion to conform to that. Second?
Yep, second.
Second, right, yeah. Okay, further discussion? Further comments? Roll call, please.
Commissioner Alcorn?
Yes.
Commissioner Allen?
Yes.
Commissioner Karapekov?
Yes.
Commissioner Block?
Yes.
And Chair LePage?
Yes, motion is carried. Thank you. Okay, that brings us to item number 9, am I correct? 8, yeah, that's what I thought, yeah, it was, yeah. We just did, Kershaw. Okay, item number 8, this is a design study, another, 25272, Gartner Project, consideration of a concept design study for demolition of a existing one-story residence and construction of a single-story, or 1,800 square foot two-story residence, and inclusive of a 200 square foot detached garage. Can we have the staff report, please?
Thank you, Chair. Excuse me. So the subject property is located on, I don't believe that's the right address. I apologize. The address is incorrect. Dolores to northwest of 10th, just to correct that for the record. It's a 4,000 square foot lot currently developed with a 1,718 square foot residence. The applicant is proposing to demolish the existing residence. Just to note, it is by definition a demolition, but the applicant is proposing to largely maintain the existing residence in the same footprint and add on to the building within largely the same footprint, but again, by definition is demolition, and construct a 1,800 square foot single-family residence inclusive of a 200 square foot detached garage. The plans also show a 800 square foot attached accessory dwelling unit. So staff is concerned regarding consistency with the design guidelines and is seeking commission feedback regarding consistency with the design guidelines, specifically pertaining to a significant oak tree that is located in very close proximity to the proposed structure. As you can see in the figure, we do have limbs that encroach into the area of development, as well as portions of the canopy that likely would need to be pruned or branches trimmed. So we do have design guidelines that speak to preserving significant trees and minimizing impacts on established trees and preserving trees throughout construction. So what staff is asking the commission to do is consider the location of the proposed building mass. The options could be to require redesign or modification to avoid impacts to the significant tree, to make a finding that the project is consistent as proposed with the residential design guidelines with evidence that the tree will be protected throughout construction. Or option 3 is to require the applicant to apply for a pruning permit, finding that pruning is not a significant impact to the tree and is consistent with the design guidelines. If the pruning permit is denied by the forester, finding effectively that it would be detrimental to the tree, the project would then need to be modified. And then again, here we have our concept findings for acceptance, which relate to forest character. Number 2 being that the project use of open space topography, access, trees, and vegetation will maintain or establish continuity of design both on-site and in the public right-of-way that is characteristic of the neighborhood. And then 7, the development does not require removal of any significant trees. And then all buildings are set back a minimum of 6 feet from significant trees. So as it relates to privacy and views, staff has not identified any view impacts with the project. We also don't have any correspondence relating to the project from any neighbors. Design guideline number 5 does speak to organizing functions on a site to preserve reasonable privacy to adjacent sites. So notwithstanding any lack of correspondence, we still do need to consider privacy and view impacts. So the proposed second story is located in close proximity to a neighboring site. So we do have the neighboring residence outlined here with the proposed second story shown in red. There's also a deck which is outlined in blue here. So the commission should consider the proposed privacy impacts of the new second story. Staff is less concerned regarding the proximity to the neighbor to the north, purely based off the setback. So again, concept finding number 5 for the commission to consider is the project is consistent with the objective for public and private views, and then retaining a reasonable amount of solar access, and then the placement and location, size of windows, doors, balconies respects the rights to reasonable privacy on adjoining sites. Similarly, for the commission to consider, this relates to scale and building and roof form. These are design guidelines that we often cite relating to human scale and simple building and roof forms. So again, staff is asking the commission to consider consistency with these design guidelines. These are purely discretionary, so staff is asking the commission to review and consider these items. So just additional elevations. And then the design guidelines that were cited in the staff report are just on the slide for reference. And then we have our findings that relate to these sections of the design guidelines. Number 3, the project avoids complexity using simple building forms, a simple roof plan, and restrained employment of offset and appendages that are consistent with neighborhood character. And then the project is adapted to human scale in the height of its roof, plate line, E-lines, building forms, and the size of windows, doors, and entryways. The development is similar in size, scale, and form to buildings on the immediate block and neighborhood, and that the height is compatible with its site and surrounding development will not present excess mass or bulk to the public. So there is a detached garage proposed to be located in the front setback. There are 6 findings that need to be made. The ones highlighted in green, the boxes are effectively checked in the staff report. The highlighted ones in red have conditions included or supplemental findings. So number 2, a landscape plan was not included in the plans that demonstrated 50% of the adjacent right-of-way be landscaped. So there is a condition of approval that speaks to that. Staff also did include an additional landscaping requirement for this area, which is currently an asphalt area now. But there is a condition of approval that identifies that this area should also be landscaped, citing consistency with our residential design guidelines. And then for number 5, effectively a finding that the project meets our previous finding on finding number 4 would meet finding number 5 for the detached garage. I I believe in the past, we've said that the garage is in scale with the site, so therefore this is appropriate. But what finding number 5 is actually saying is all development on site is in scale with adjacent properties. So that's not just that the garage is in scale with the property, but the garage is in scale with everything, as well as the rest of the development is appropriately cited. And then other findings that aren't specifically addressed through individual design guidelines. Number 1, the project conforms with zoning standards. So staff did take a look at that. Everything appears to be in order. If we did miss something during our review, we'll be sure to address that as we continue to work with the applicant. Number 6, the design concept is consistent with the goals, objectives, and policies related to residential design in the general plan. So there was an excerpt or an attachment in the staff report which highlighted those sections of the general plan. Again, these largely relate to findings that are implemented through the use of the residential design guidelines. So a finding for consistency with the design guidelines would effectively, you could use as a finding for number 6. So with that, staff recommends the Planning Commission consider the project and either 1, make a finding for approval to adopt a resolution, being attachment 1, or continue the project with the direction to the applicant. And that concludes my presentation. Happy to answer any questions.
Aaron, you mentioned those 2 policy statements about complexity project avoids complexity, project adapted human scale. You just brought those up. You didn't have any discussion about your opinion that it meets those particular guidelines or not, or are you just pointing them out to us?
It's a determination for the Planning Commission based on the residential design guidelines. It's going to be the same discussion that regularly comes up regarding having being adapted to human scale, the grand entries, complex roof forms.
So you're suggesting that this project is, the discussion of this is pertinent to these particular
I highlighted the design guidelines that I felt warranted discussion.
Okay, all right, thank you. Any other questions for staff? Yes.
Mr. Court, slides 9 and 10. Perfect, here's slide 9. I like that. So in the lower illustration, there is what appears to be a second-story deck. And my question has to do with comments about the second story and privacy and views, Design Guideline 5.1. Because the current home, we weren't able to see a second story, so we actually don't know what that view might be like to its neighboring property to the south. Can you speak to that at all?
So the finding is, through the placement, location, and size of windows, doors, balconies, the design respects the rights to reasonable privacy. It's not absolute, it just needs to be reasonable. So can we presume that, or find, that the deck provides reasonable privacy? And that, again, it's a discretionary decision for the commission.
I see.
What is reasonable privacy?
I see. Thank you. I'm getting a lot of these answers tonight. And one other question on the roof color. We saw a palette, didn't we, somewhere in here?
It's in the plans. It's not in my presentation.
But it's not black, is it, or deep gray?
I don't recall. I didn't do an analysis on that for this concept staff report.
Oh, that's more final.
I'm
right.
looking-
So it's a final detail.
Okay, then never mind. Thank you. That ends my questions.
I have it right here. The color is called weathered wood. Yeah, it looks to be like a pretty dark brown, maybe. I don't know if anyone might be still listening in the back, but I'm sure we have that sample.
Okay, all right. I'm going to invite the applicant to come forward at this time, make their presentation.
Thank you. Good evening, Chair, Commissioners, staff. I'm Harlan Bradley. I own Masterwork Builders. I'm the designer and the builder for the applicant. I have my clients, Scott and Diane, here with me this evening as well. And just to answer that question right off, this is an inspiration image with the color palette of all the materials. And this is the actual sheet from the plan set. So I wanted to address the few concerns that have been raised with the project, which are, one, the oak, the massing, and the privacy. And we were very deliberate in the design of this addition with respect to the oak tree. And I think you probably saw when you were on site today that the addition tucks in really nicely behind it. It does barely encroach into the canopy. We would defer to the forester and have spoken with him that a pruning permit would be necessary, and we would accept his guidance on how best to preserve this oak. It is a very large, multi-trunk oak, and so the site plan, you can just barely see the center where all of those trunks come up right now. It's about a 40-foot diameter canopy, and the second story that we've proposed just barely touches the edge of that. I think that we're so far from the root zone as well that there's very little risk posed to the tree long-term. I also think with respect to the massing, because that tree is so prominent on the site, you really can't even see the second story addition. I think if you were driving by, you probably wouldn't even have noticed the story poles that we had up, other than the garage where the proposed acacia is proposed to be removed. So one thing to note on that as well is that we cited the second story in that location because it sits over an existing depressed area of the floor plan. And so that allowed us to keep a lower height overall. If we had shifted that to the north or to the east, we would have been over a higher plate height, and therefore it had a larger mass overall. So Scott and Diane were okay with the existing kind of split level floor plan that exists, and that allowed us to put the second story over that area. It will provide them a modest ocean view. That was the original catalyst for the project, was to put a primary suite upstairs where that could be enjoyed. And we believe that the privacy concern will be negligible, but we're open to adding a privacy screen or a raised planting bed on that deck if needed. So we hope that you like the design. It's classic Carmel. It's a beach cottage, shingle. A lot of the elements are drawn from the existing Carmel Delight cottage that's there now, with the shingle exterior, some of the arched lattice work, a very humble character, and we believe we've maintained that while making it relevant to the modern day and a modern lifestyle.
So can I ask you a question?
Yeah.
So the way we're looking at the house right now, is that south elevation? We're looking at the house from the south, right?
Yeah.
Because it has all this shadow, or shadows on this side. It kind of implies that the sun is coming from a different direction. Okay, is there any particular reason why you didn't put bigger windows on the south side to get more light in?
For the privacy concern.
The privacy, because there's another house.
That's correct.
Okay.
So the two windows that are there, the one that's further west is like a clerestory window that's in the bedroom. That would be a high window, maintaining privacy to both neighbors. And then the front window is actually bathroom. So we've noted that it would have a motorized shade, and we're also proposing that that be opaque glass. Again, maintaining that privacy for both neighbors.
So really, if the idea is to get light from the south, wouldn't you move the house, the living area where the garage is? Because the garage seems to be getting most of the sun right now, right? It's further away from the other house, and it is facing south, and you have space in front of it.
Correct. So the house itself is just behind the front yard setback. So we wouldn't have been able to bring any living areas further east into the front yard, although that would be nice in practice. but the zoning guidelines don't allow for that. And as far as shifting that second-story mass north so that it would have more southern exposure, the primary reason was because the height of that floor would have pushed the second story up too high. So we're trying to keep the mass and the overall height within the additional guidelines for volume and massing. And that was the primary driver for keeping it down on the southern side over that depressed floor area.
Okay.
Yeah. Okay.
Harlan, I had a question for you.
Yeah.
And please forgive me if I'm being presumptuous here, but I'm just looking at this for the first time. And I know that you've been working this a long time, and you've had certain challenges here that I'm not aware of at all. I guess when I'm looking at it, I see a little bit of, well, first of all, I see your design has a repeating gable with this round vent, and then you've got the returning eave, which is kind of a classic treatment. And then the entryway, there's a shed roof that goes into this lower pitch entryway, and it just seems to create a little bit of business in there. So I'm kind of wondering what happened with the shed roof. Is that necessary? Is there another way to, clean this up? Like I say, I'm just looking at this for the first time. So, why was there a need to have this shed roof in there?
So the existing roof is very shallow, and so we're really just trying to accomplish enough drainage out to the front of the roof line. That's really the only reason for that.
Is it just it's not a vaulted ceiling in there?
It is a vaulted ceiling.
It is?
Yeah.
So
we're trying to maintain
so where
that
that
vaulted
shed is, are
ceiling.
you looking at the bottom of the?
No, the shed would just be actually on the top.
So that's added over the
just for
existing
the purpose of
pitches,
drainage. Correct.
Yeah, it just kind of competes with a lot of the other, the gables and so forth. And I know this is a two-dimensional drawing too. In three dimensions, it looks different. But, I guess it's set back where that shed, is it shed even with the gable right next to the right of the entry?
It's tucked back a little bit. We did originally have the porch coming out further, but we took staff's direction to reduce it in order to reduce its overall mass.
But that shed is primarily over the entry, right?
Correct.
So is the line of the shed pulled back from the front of the entry there? That's about, looks like about 2'6", 3/4 or something. I see that dimension.
The idea is that by line of sight, it will
You
basically
probably got a roof
recede.
plan. I probably should look at the roof plan.
Chair, Chair LePage, if you look at the monitor, the laser pointer shows where the edge of the shed is.
Oh,
on the
yeah, you can see the
elevation.
little cut there, yeah. Yeah, it's hard to see it. Yeah.
I do think that in reality, when you're standing at the front of the property, you won't actually be able to see that.
Yeah, I guess the other issue is I'm always looking to see that the pitches are consistent and the entryway has a lower pitch. If you raise it up, I guess that would cut into the second-story window line, correct?
Yeah, and we are trying to preserve that front room. So, as Mr. Court pointed out, this is technically a demolition, but there is quite a bit that we're going to save of this property, and that front room is the primary part that will remain.
Yeah, but the second story, that's all new.
Correct.
That's all new. But anything you do on that entryway where it butts into that, like I said, it's the east facing, is that the east elevation?
Yes.
Yeah, kind of the ridge would become higher. Either that or you'd have to lower the columns, which could have other consequences. That's why I say when I'm just looking at it the first time, I don't see all the consequences of, you do one thing and then it affects other things.
Yeah. Appreciate that.
Okay, thank you. Any other questions for the designer?
Yeah, the other comment I have is, so the tall part of the house on the left is now very close to the house on the south, right?
It is.
Is there any way to move that mass to the back and to the north? In that corner where is nothing. I saw there's nothing on the behind the house. There's nothing, right? The next house is far away, and on the north side, I don't remember. I think there's not a big building on the north side as well.
The reason for that, we've pushed it as far west as we can for the height of the floor. So again, the bedrooms that are west of the second story on the first floor, they're at a higher level. And so we basically run into, about a 6 foot, 5.5, 6 foot plane if we were to bring that upper floor further west. So that's the reason for it's kind of boxed in, if you will, between these adjacent higher first floor areas.
It's just that our design guide talks about the fact that you do not want to have this tunnel effect, so that you don't want to have two tall buildings next to each other, and they're pretty close. And then also it's talk about the fact that the second floor should be offset so that you don't have like a one straight wall going from the ground up to the second story or to the roof. So I'm trying to figure out how we can move that mass so that A, we can get it away from the other house, and B, get more light into the new house. Because right now they're so close to each other that there will be some privacy issues, obviously, because they're very close to each other. And also it impacts your design. That's why you're keeping the windows small, which is kind of counterproductive because this is the south side where the sun comes in. And then at the same time, you're creating that wall that is aesthetically not that pleasing. That's why our design guide talks about, break it up, move it somewhere to the middle, distribute the weight in a way that, the taller part of the house is in the middle and then everything else is subordinate, right? So that's what I'm trying to figure out if it's possible to do.
We felt like the articulation that we did add, where the bathroom of the upper floor, which is closest to us here, it does articulate to the south. And then the portion of wall that is continuous from bottom to top is very short. That's essentially the bed wall of the primary bedroom. It's really only about a 12 or a 13-foot wall. And then the deck has a little articulation as well. So although it's very difficult to see this side of the home, we agree with those design guidelines, and we feel like the elements that we added here speak to that and do have some articulation and interest.
So we have seen many projects like this where the slope is exactly like that, and most of the proposal end up being split level.
Yeah.
So you walk down to a living area, and then you like a half story down, half story up.
Yeah.
And that's how you get closer to the light on top, and you push the mass towards the other side of the lot, to the back of the lot. And that may work well, actually.
It would, and if we were truly starting from scratch, I would absolutely recommend that to my client. However, we are trying to retain a lot of this existing structure. And so we do have a split level design. It's just that the small portion of the existing first floor that is split down is only the footprint of the upper floor that you see. So that's literally, the thought process and how we landed on putting it in that spot. It's really the only place where we can build on top of. If we shift it north or west, we're too high, the mass has gotten too large. So we just tried to tuck it in right there.
So what you're saying is, so you have this lowered, living room.
Exactly, it's like a family
And then
room.
you put the master right above that.
Correct.
And the setback on the south side is 6'5".
I'm sorry, I gave
Yeah, I
my
mean,
plans
I'm
away
looking
to reference.
I'm looking at the
But,
proposed site plan. It
yeah,
looks like the
it is.
house to the south has a part of the structure is right on the property line.
It is, so it's a
What-
little
what is that?
deceptive when you look at it on site. You may have noticed today, the fence line is actually significantly into Scott and Diane's property. So that's, something that we'll have to deal with as construction and permits continue, a conversation that they'll have with their neighbor. But it is worth noting, their neighbor is in town. I saw them today on site. They seem happy with the design. There was no objections raised at all.
So they didn't have any privacy concerns or anything?
Yeah,
Okay, all right, thank you.
thank you.
Okay, we're running out of people in here. Did the owners want to address us?
Hi, Scott Gardner, my wife Diane.
Come on up.
Thank you. Hi, I'm Scott Gardner with Diane. We've owned the house for about 11 years. I'm a professor at Naval Postgraduate School, where I just recently stepped down as Provost and Chief Academic Officer. And our goal is to be able to accommodate our expanding family of our adult children whose families are expanding with a little bit more space. So, thank you. Appreciate your guidance and what you do for us and for the city. Thank you.
Okay, thank you. Any hands up online?
No, sir.
Okay, I'm going to close the public comments, open it up to the commission. Commissioner Alburn, you want to begin?
Sure, thank you, Chair. Overall, after visiting the site today and seeing the proposed plans, and seeing the way that the architect and designer has fit this into a rather challenging site, given the size of that stunning tree. And they have used a very sensitive treatment to protect that tree. And we heard that they've spoken with the forester, so there are plans to discuss possibly a pruning permit if need be. I am very comfortable with some of the conditions of approval that Mr. Court has suggested, and I recommend that we simply accept this design study concept.
Okay, Commissioner Allen?
Yeah, so I would like to explore the pruning situation first before we move forward, just to ensure that we're aligned with what the forester would suggest in terms of what you can and cannot do with the oak tree. But otherwise, I like the design. It's super interesting how it kind of just like fits like a Lego piece, where the big piece comes in and then the L shape matches on one level. Interesting. So yeah, and then I really like the fact that you brought an inspirational photo, because that answered my questions about the French doors down at the lower level. So yeah, I'm good with the design.
And Commissioner Locke?
I don't really have anything to add. I think it's just fine the way it is. I'm actually looking at the neighbor house online right now. And I'm glad you reached out to them, or at least you'll have the opportunity to talk to them.
And Commissioner Petkoff?
Yeah, I like the inspirational photo, and basically the question is then what happens when you have this inspiration and you put a giant oak in front of it, right? That's what happens. You have to adjust your inspiration according to the oak. I still think that we can, that there are some things that can be improved in the house in terms of moving the mass around. Maybe not completely move it to the other part of the lot. I understand the limitations of the lot, but avoid having this straight wall on the left side, on the south side. Moving a little bit away from the neighbor, maybe having it centrally instead of having it on the left side. And also in terms of simplifying the roof, especially in the two-story section, maybe if the roof is just a simple gable, like the one here on the inspirational photograph, that would help a lot. Right now it's more of a two gables meeting each other, and it becomes bulkier and it becomes more complex. So maybe that simplification will bring some improvement. I understand the limitations of trying to work on a small lot and with a giant tree on the lot. So yeah, and in terms of design elements, there are a lot of design elements in this house, and our design guide is, and I agree actually with the planning department suggesting, simplifications. I think we should look at simplifying the roof forms, maybe standardizing some of that. Right now we have different kinds of roofs. Some of them are look like 312, some of them are 412s, 512. So I want to make sure that there's some consistency in there. I guess this little design elements around the edges of the roof is something that comes from the inspirational photograph, so they cannot go away. But the arches, for example, they are very well synchronized here on the inspirational photograph. You have an entire section of the house that has 3 arches next to each other, and they're same size, same material, same color. That makes a lot of sense. In the plan that we saw, there are arches, but they are not exactly aligned. And they are a little bit off. And it's really, in design, it's really noticeable when you have slight deviations from a pattern. So either we make they should be similar to that, maybe look the same color, same material, or maybe go away, just don't use arches at all if that doesn't work. Yeah, these are the comments I have. Hopefully we can have some improvements to the plan. I wish there is a way to use the lot more efficiently, but with this giant oak, I don't think you can do much. It's basically taking one of the best parts of the lot, so you cannot really build on that, and I don't want to see the oak damaged or cut in any way. Digging into the ground, maybe, to address the issues, maybe some excavation. I'm not sure what they're planning to do in terms of keeping the foundation, but one way to reduce the bulk and mass is to excavate, and we are not very happy with that, but if that's the only way to kind of solve the problem, maybe excavation in the north part of the lot is an option. So I'm just brainstorming here, maybe some ideas that we can look into. Thank you.
Okay, it sounds like we've got 3 commissioners that are pretty good with the design.
So on that second story, in your opinion, Chair, is there a way to simplify that roof on on the second story?
Well, I was looking at it, and it's interesting because you have, you've got the gables. The gables are kind of decorative. The ones facing east and west. Mm-hmm. Yeah. And the east-facing gable really does contribute a lot to the consistency of the design. It looks like the plate height at the east, it's significantly higher than the plate height on the west. So it's almost like a salt box in a way.
Oh, yeah. Yeah,
and,
you're right.
Because of the height difference, if you just ran a straight ridge line east to west, you'd actually end up with more massing to the south, I think. The way it is now, I understand Commissioner Karapetkov's concern about large 2-story elements, but there actually is articulation there. You've got an offset there, and then you've got a lot of different heights. So there's quite a bit of articulation along that property line. So the only direction I would give to the designer is maybe explore some ways to simplify the roof a little bit. It's a challenging design because you have done something which we really encourage, and that is you've got the house following the slope, and that's very important. And that that contributes to reducing grading. It also reduces height and massing, and that's something we encourage. So, and when you start with that, that drives the design, and so you end up, with what you end up with plate heights and so forth. And because it's following the slope down, you've got different plate heights. And so that you've responded to that in the correct way. So a lot of these guidelines about how to build the form on the lot, they determine what the eventual form above the lot, becomes. And then the designer takes takes your creative inspiration, and you apply that to the design, and that's how you come up with this. So I see the way you've gone, and I think you've come up with a pretty coherent design. But there again, this is concept, and maybe take a look at the roof form and see if there's something you can do there to simplify it. Other than that, I think it's a very, and I think, you might, when you're looking at the roof form, think about the two elements which are pretty dominant are the second story and the entry. So if you did something there, maybe, or looked at that in a creative way, stay true to your design, because I think you're on the right path there. So that would be, I think that's really the only direction that I've heard that the designer could take a look at. And it is concept. So that we have a resolution up here. I looked at it. And I did with it. I brought the roof up. The weathered wood presidential. It's a real nice variegated color. Yeah, it's got a lot of dimensionality. It's got some light flecks in there, so it's not a high contrast kind of thing. It's a very nice looking composite roof, and it has the presidential comes up with a very nice butt shadow groove, which adds a lot of dimensionality to it. It's also got that staggered kind of offset, which I think creates more of a cottagey, informal look. So it's a nice material. Although we're not really getting into that now, but it always comes up. It always comes up. Okay, I think I have it right. So once again, we have this is a draft, a design concept draft consideration. Is that the correct phrasing, Evan? I want to get that right.
It's a concept design study, concept design review.
Acceptance.
Yes, you're accepting the concept design study.
Okay. All right, well, I'll make a motion, we accept that with the direction to the applicant to explore simplifying the roof forms. Anything else you want to add?
Yeah, and this is based on the pruning situation, right?
Yeah, this would be contingent upon it receiving approval
Yeah.
for pruning the oak and the east elevation oak.
Yeah, correct. The resolution doesn't have specific direction as a condition, so you can add the condition to apply for a pruning.
Okay,
permit.
yeah, okay, the condition will be added, number 4, that the applicant will apply for a pruning permit with the city forester.
Perfect. I'd second that motion.
Okay, any more discussion? Okay, roll call, please.
Commissioner Alborn?
Yes.
Commissioner Allen?
Yes.
Commissioner Carapetco?
Yes.
Commissioner Locke?
Yes.
And Chair LePage?
Yes, the motion is carried. Thank you.
Thank you.
What's going on over there? Yeah, this is, the hour is definitely getting late. Can we get some of that caffeinated water? We gotta revive a commissioner.
What is this? Somebody needs a cup?
What? Oh, this for you? Okay. Oh, it just keeps going. You'll never see that glass again.
Okay.
Coming back your way. Don't worry, we got you covered. All right, where are we? All we got left is Claudio. Number nine. Number nine? Where is that? God, I don't know, this new format you guys have, I have a hard time. Here it is. Okay. Number nine. I gotta get this thing loaded here, I'm sorry. Gotta open it up. Okay, is this the KRUGLER, right? If I got that right? I'll make sure I'm just saying, okay, so this is a design study, 25357 KRUGLER. This is track one design study referral for request to amend conditions to approval of a previously approved track two design. Staff report, please.
So in October 2021, the Planning Commission approved a design study application via the adoption of Resolution 2021-54-PC. As part of that resolution, the Planning Commission included condition of approval number 29. That condition is described on the slide. Notably, the condition required for the applicant to submit revised plans, which include landscaping on the south side of the garage that grows or climbs at least halfway up the south-facing wall, that wall of the garage, and that landscaping be maintained in good health for the life of the project. This condition was included following deliberation of the Planning Commission as a means to, I'm quoting, to soften the south side of the garage. So in November of 2023, staff inspected the site and found landscaping had been installed consistent with the building permit application. Obviously, it's not at a mature height. The planting's rather young. It's difficult to see in the photo, but there is a wire trellis that is installed that is located approximately halfway up the garage. At some unknown point in time, the landscaping failed to be maintained. The subject, so I apologize, this is a climbing hydrangea in this photo. So the hydrangea failed to be maintained, and it was replaced with bougainvillea. It's estimated that this replanting occurred in the summer of 2025. So staff inspected the site in September and October of 2025. The photos from September are on the left. Photos from October are on the right. So it's just a comparison of each individual plant, documenting the health of the plant from 1 month to the other. So staff, with the concurrence of the city forester, identified that the plants were not growing and being maintained in good health, and provided a compliance notice to the property owner. As part of that compliance notice, staff outlined options to the owner, being that they can amend the planting, submit evidence that the landscaping is healthy and in compliance with the condition, or submit an application to amend this condition, condition being condition 29. In November of last year, the owner submitted a design study application requesting to amend the condition of approval. So the applicant has, as part of their application, proposed to replace the landscaping with a fence. As described by the applicant, it would continue to meet the intent of condition 29, being to soften or break up the massing of the garage. The benefit of this, as described by the applicant, is that there's no biological maintenance or biological uncertainty. So the options before the commission are to rescind the existing condition pertaining to landscaping, so that's condition 29, and approve and require fencing on the south side of the garage to match the existing fence at the front of the property. Your action here would be to adopt the resolution provided by staff. That's attachment 1. Notable conditions included in that resolution are to require the fence be maintained, much like that landscaping was required to be maintained. and also identify that the fence is required to match that of the existing fence. Option number 2 would be to rescind the condition altogether pertaining to landscaping. This effectively is a finding that the project, without any additional softening or other design treatment, is consistent with the residential design guidelines. So that was the initial issue, was consistency with the residential design guidelines. But here, reevaluating the project once it's completed, it would effectively be a finding that the project is fine and consistent with the design guidelines. As part of this action, you can make a motion with findings pertaining to the project's compliance with the design guidelines, striking condition 29 from the resolution, and directing staff to amend. The resolution here isn't clear, but what we would do is amend a new the resolution we prepared, attachment 1, effectively striking the requirement for a new fence and addressing the elimination of condition 29. And then option 3 is to uphold the original decision. The landscaping would be required to be maintained, and the original approval remains in full force and effect. If you wanted to take this action, you would motion to deny the request and direct staff to prepare a resolution for denial. Additional options, you could provide direction or suggestions for alternative planting, or direction to staff regarding enforcement of the condition. So staff's recommendation is option 1, which is to adopt a resolution amending condition number 29, which is effectively striking that condition and requiring the installation of the 4-foot tall fence. And that concludes my presentation. Happy to answer any questions.
Questions for staff? Okay, would the applicant like to come forward and make their presentation?
Good evening. I'm Claudio Ortiz representing Eric Krugler and Erica Krugler on this project. Just a very quick, brief story. I know it's getting late and I want to go home, and I'm sure you all want to go home. So the project started as a remodel, and the existing residents had a parking pad in the front. And the concept evolved to remodeling the home, doing minor additions, and in that process, building a detached garage in the place of the parking pad. So that's how we came up with the parking pad or the garage concept. As you can see, the site itself, there's really no other places to propose a garage. So that was at the time when we were designing the home, that was the best decision and location for the garage. In that process, Mr. Kovic, has some concerns with the garage, and rightly so. And he brought up concerns with the south elevation of the garage being too plain or boring, or I'm sure he can address those concerns. But in that process, he wanted to soften the elevation, and he asked if we can propose a window, and we couldn't. We can't. You can't propose a window within 3 feet of property line. It's a building code requirement. And so the alternatives were to, come up with a solution to appease Mr. Kovic. At the time, not thinking of all the scenarios and the outcomes of any decision, but at that time, the best decision was to find a solution that would appease Mr. Kovic and my client. And that solution at the moment was to propose some landscaping. We figured landscaping would be a pretty alternative. It will be, adequate for his suggestion. And so we decided to, move forward with the landscaping process. Unfortunately, not knowing all the scenarios and not studying all the details at the time, we just went along with the concept to maintain, to appease the neighbor. So I would like to pass these diagrams and plans, if I may. Can I pass these around, or? Okay. So there's, let me see here. I stapled a photo and a landscape plan. And what I want to demonstrate is that, as we do more research and, revisiting this whole concept, there was a concern with privacy, and I believe I have enough for everybody. So there's concern with privacy, and the more I look at the project, the way the building, and you'll see this in my site plan, the way his building is situated and his views are oriented there to the rear of the property. And he has down the hill, if you, I don't know if you recall, but when you were standing there looking down the hill, he has a window that's a kitchen. So he's concerned about, this building being an obstruction or an eyesore to him. In my opinion, you only see that garage when you drive in for a few minutes, a few seconds, I should say. He parks the car, he goes to the bottom of the hill to the home and moves on. So my point that I'm trying to make, though, is that, how often is he looking at this building, this detached garage, right? It's only maybe when he's standing in front of the kitchen. And I'm not trying to argue that this is not an eyesore to him. I'm just trying to demonstrate that if there was a situation where this garage was seen from a habitable, from a living space all the time, then I can see, really fighting hard to come up with other solutions to find, an alternative that will be to keep both neighbors at peace. And so I just want to simply demonstrate that, there's really no privacy concerns or views that are being obstructed, or that this structure is an eyesore to his full-time living when he's at the property. With that said, I also, at the time we didn't study any of those details. We just went ahead and decided to put the landscaping. What I also want to demonstrate is that I drove around town looking at detached garages, and I found quite a few, but I also focused just mainly on the detached garages that the neighboring property had a driveway, almost similar condition that he has. And every single one of them, has a fence. There's really no landscaping around it. And all of those projects, out of those 5, 3 of those are my projects that I've done. So I can say as a fact that none of the neighbors ever complained about that, about the detached garage being placed in front of the property and being an eyesore or an obstruction to their everyday life. So I just want to demonstrate that what we're asking for or what we're proposing is not something that hasn't been done before, or something that we're going out of our way to, create an obstruction to our neighbor. And I can add more so that, I think what he's asking is probably something that is I've never seen any neighbor asked before. So I feel that the fence is a really good solution because, again, at the time, not knowing all the, issues with the site, issues that we were going to have between the neighbors, because you have to think that landscaping requires going into his private property, maintaining it, and also you have to take into account, not that the KRUGLERs are planning on this, but if they were to sell the property and 10 years or 5 years down the road, somebody buys a property, how does the city enforce the landscaping? And how does Mr. Kovic enforce that to the new neighbors? There's always going to be disputes. And I think for having or bringing peace to both neighbors, I think the fence is a really good solution. It really achieves what he wanted originally, which was to soften the elevation. By providing a fence, it breaks the elevation. It was very apparent that at the hearing, it was said that only half of the height of the wall needed to be obstructed or softened. And I think the fence is a wood material, natural material. It's used throughout Carmel to, provide privacy and separate properties and so on. It's a material that meets that criteria. But more importantly, that fence is something that doesn't need to be maintained.
Claudia, I read the letter from Mr. Kovac again. So he's not specifically requesting landscaping.
Right.
He just, as he says here, I've spoken with the owners and the architect, and they are working on a solution that will be done to address my concerns. So as he said, he doesn't want the landscaping?
So when,
Oh, is this Mr. Kovac?
yeah.
All right, well, I'll wait to ask you that. I'm sorry. I will ask you that in person. Go ahead.
So at the time, the concept was to soften it. And in the conversation between neighbors and all of us, it came to landscaping could be a solution. And like I said before, originally, at the time, in that position we were in, we felt that that was the best, solution. We were trying to appease the neighbor and provide something that would be, a great solution to his concern. Again, not knowing that landscaping would be very difficult to maintain. And I think, in my opinion, I'm not a landscaper by all means. That's one of my, I'm horrible with plants. But the one thing that I can say, though, is that because there's so much asphalt in that area, it heats up, it probably produces a lot of heat. And so landscaping is probably very difficult to maintain. I think he mentioned something about planting some sort of evergreen trees, but my concern with evergreens is that they're going to have roots that are going to invade his driveway or our footings or the structure, and it's going to become an issue down the road. I think the best solution, and it's a solution that has been throughout all of Carmel, which I demonstrated in the photos that I provided, is that a fence is a acceptable solution. It breaks up the elevation. It doesn't require any maintenance or any necessity from Mr. KRUGLER to send landscapers to his property, because I can assure you some issues are going to come up later on in the future if we continue doing landscaping. And I'm not trying to avoid the whole thing, but I'm trying to find a solution that is practical, is reasonable, makes sense for everybody and puts it to rest, and we move on. And because my gut feeling is, if we continue with landscaping, it's probably going to fail down the road again. And we're going to come back, and we're going to be requesting, hopefully, to amend it again. We're going to continue this process. So.
Okay. You're not proposing the fence?
I would like to have the fence, yeah.
Okay. Let's hear from Mr. Kovac.
Thank you.
Thank you.
Good evening.
Sorry to keep you so late.
I'm seeing double. I gotta commend you guys. Evan Court, everybody, his staff, I couldn't do what you do. I would be drinking a lot more red wine than I'm drinking. I didn't want to be here tonight because normally I volunteer to teach a self-defense class at the youth center along with other black belts. We teach kids and we volunteer our time. We charge $20 a month. We never take a salary. You may have heard 4 months ago, one of our girls defended herself from a mugger in Carmel. That was one of our students. And it went nationwide and did more for the people looking into self-defense than we could have advertised in a lifetime. That being said, I wasn't going to come, but my dad was from the old country. He was Yugoslavian, he was a mountain man, and he told me, you shake a man's hand, that's all you need. Your word is your bond, okay? This has been a complete opposite of that, okay? At the Planning Commission meeting, you were there, Chairman, that you all agreed we needed to soften the wall, okay? If we didn't have enough room to do the planting, we were going to move the garage a little north. That was going to be a discussion between me and Mr. Claudio Ortiz. That never happened. So now that ship has sailed, and here we are, okay? This is the second home, okay? I bought this home in 1983. It was our first home. It was during the big first El Nino. 1 week after we bought the house, I lost 20 feet of the backyard. It was just a mess. My neighbors at the time, old military, They helped me out. I was hoping the same thing would happen with this neighbor. It hasn't. When they planted the first planting, and I mean, they did nothing other than dig a hole and plant the plants with a gardener, not a landscaper. They never fertilized it. They said they had a drip system. Why did they come and water it every time they came down? They never took care of it. The plants died. I wasn't supposed to maintain it. I would have. I sent an email and a letter, and that's what brought this all up, because nobody was aware this was going on. Okay, that after 3 years, I still have a white wall. And Mr. Ortiz is incorrect. Not only do I view it from my kitchen, looking up the driveway, I view it from my bedroom. There's a chair that looks directly on it, okay? This, if I had to overdo again, I would not have the garage. All it serves is a little EV station charging. It blocks the view, okay? If you'd noticed and you took the tour, you'd noticed all my cars are parked so we can drive out. Because now when you try to back out, people zip down that street, and I've almost been hit twice, okay? So it's not only, is it dangerous, it's cumbersome. Now, what they are proposing, I can't imagine in my wildest dreams that this is gonna soften the wall. What does a low fence that's dark against a white structure soften a wall? The wiring that was installed, my son came up with the idea. They had no clue on how to do it, okay? When the second planting of the bougainvilleas, my son noticed that the rabbits were eating the plants. He went out, because he's studying to be a master gardener, and bought plants that deter invasive little guys, right? And he put little screens around each one of the plants. Mr. KRUGLER came down and said he wanted them removed because we were trespassing. Where does this come from? You have to cross my property to plant the thing. How did they plant the plants in the first place? In the second place, they never asked permission. I would give it. It's common sense. He's got to come on the property. And as far as this radiation of the concrete or the asphalt, that's ridiculous. There is a self-planting oak tree there, and it's doing fine. All you have to do is dig up the soil. They just use the existing soil, put in new soil. I'm not a landscaper. And garden and maintain it and fertilize it. And once it is and you even suggested, what was it? A pear, something pear plant.
Sky there.
Yes, okay. And
It's all coming back there.
no, right, exactly. So,
Which shows I still have it.
yeah, okay. And all I'm asking for is a vining evergreen that maybe could be flowering, that's drought tolerant. Once the plant is established, nature is going to take its course and water it. We can water it. I can take that off his plate if he needs to. They rarely come down. They never see the wall. They don't do anything. If you guys okay this fence, then all this is for naught, okay? I see the detail you take. Evan and his staff, it's amazing, the hours that you guys put in to make things right. And now to put up this little fence, what does that actually do, okay? I'm gonna close with, I had this long thing I prepared last night, 12:30 at night. Okay, I got it all right. I pushed the wrong button and it all went away. And I'm going, I can't do this, okay? I can't do this. So I just gonna go off the cuff. And the only thing I was my closing is to give you a vision, okay? And I'm gonna read this because I couldn't remember it. Envision you're driving north on Crespi and you see a small grape stake fence along a bare white surface. Do you think, what is the purpose of that fence? Is it deterring the garage from any intruders? Now, the same vehicle driving the same course and they see a wall with greenery and flowers. Maybe they think, what a pleasant way to hide a giant white box, and they feel the charm of Carmel. Isn't that what we're after? More greenery? If you have any questions, I'm at a loss. I've been dealing with this for 3 years.
So I have a question. If it's the color of the box of the garage, would it help if the garage is painted in a dark color?
No, I mean, the whole garage is white now, okay? Okay, and you can't paint it because it's a shingle that you can't paint. So it's all, the back, the front, and the house is the same thing. You can't change that.
Well, the garage can be in different color. There's no rule that.
Well, that's
the
still
garage-
not gonna, so what? We're gonna have a black, instead of a white garage? That reflects the heat anyway. When you look at the design, and no remarks on his design, but to move the structure 6 more inches would not have affected anything. As you look at it now, you destroy the beauty of the entrance because what you focus on is a box with a garage door.
So how about planting something in the back of the garage? So that it's in front.
They don't
of
want
you?
to plant anything anywhere.
No,
So-
there's no door. I think the door to the garage is on the side, so the back of the garage
No,
is
the
free.
door in the garage is right in the front. As you drive in,
And side door, there's no side door?
no side door.
And what is in the back of the garage? Nothing, right?
Nothing.
No, you can't plant behind the garage.
There's no space
My
there?
son tried to prove a point and planted, if you went on the tour, he planted some plants to the east of it, going down the driveway.
Yeah.
How is that possible? Is that a miracle? Same kind of situation, same soil, but what he did was change the soil, nurture the thing properly. You can't just ask a quote-unquote gardener, dig a hole and put 4 plants in.
No, clearly these plants are not gonna survive if you don't, this is bougainvillea, right?
Yeah, and
Yeah, bougainvillea requires acid soil, so you have to buy special soil with acid in it to.
but
feed
it's
it,
gonna take
right, yeah.
forever for that bougainvillea to go halfway up the wall or partially up. Right now, they're almost dead.
That is true.
You know what, bougainvillea isn't gonna grow. Every picture we've seen at all different times is shaded, and so it's not gonna grow there. I can guarantee you.
And if it did grow, it's gonna be dormant half of the year, and I'm gonna be looking at dead vines. Just do the simple thing, 4 evergreen vining plants that grow fast. I'm sure our city forester can recommend it.
But vining plants will go underneath the shingle.
Pardon me?
They go underneath the shingle and.
No, there's wires that my son devised. They wouldn't let us put any spikes or anything in the wall, so my son says, how about this idea? And it works, if it would work.
I think you've answered the question, that is that you are in favor of the landscaping and not in favor of the fence, correct?
Yes.
Okay, all right. Let us discuss it and we'll work it out.
Okay.
Okay, thank you.
I can sit down.
You can sit down.
But did you have a question before for me?
You answered it.
Okay, all right.
I wasn't sure where you stood on the fence,
Okay.
but now I am.
Quite clear.
I'm totally clear. I have complete clarity. All right, so no hands up there. Do you want to respond?
Yeah.
I mean, we know you want the fence.
I do.
If you have anything new to offer, otherwise, let's just talk about this and work it out, okay? All right. Okay, Commissioner Locke.
I would stand for the condition of approval on this. And I'm sorry that this has happened. I was there, so I remember the approval of this project. But I think, and coming from somebody who actually just wrote an ordinance about landscape water use, that there are ways to determine what's wrong with the soil. If there's a problem, you can amend the soil, whatever. It sounds like that may be the issue. And I would also suggest that whatever the appropriate plant is to go in there, that they are larger plants than these teeny tiny little things that have been put in the past. That's my position.
Commissioner Allen?
I'm with Commissioner Locke. I do feel like this these pictures don't reflect this situation. It's just one white wall down the whole thing, completely bare. And a fence does not solve the problem. So I would like to see a solution with some beautiful greenery.
Commissioner Alborn?
Thank you, Chair. I think that the fence solution is a solution for the property owner. I think that the fence will be easier to maintain and more sustainable. I think the landscape solution is in keeping with our design guidelines. And my question is I'm not familiar enough with how far the city goes in encouraging a property owner to comply with conditions of approval with things like landscape. I would be inclined to prefer seeing landscape there than a fence. A fence usually is used to denote an enclosure, and there's nothing there to enclose. I don't want to see more landscaping if it's going to fail. However, maybe the city has means of code compliance where it can encourage the property owner towards methods of landscaping that will be sustainable. I have questions.
Commissioner Karapetkoff?
I'm also for landscaping solution. I don't think that the fence is gonna make it nicer. It's actually gonna get worse. So what kind of landscaping? There's already water. You saw there is a plastic pipe, so I suppose it's connected to a timer, so to get water periodically to these plants. But the problem is that there is not enough space for them to develop a root system because it's only like, say 6-7 inches of soil there, and then the soil has to be changed. Now, if the neighborhood situation is better, I would suggest removing some of the asphalt so that there is more space to develop the root system, so for a normal plant to grow, and maybe putting some trellis attached to the wall so that the plants have something to climb on, not climb on the shingles, because plants touching shingles is never a good idea. They are gonna rot on really quick. I mean, it just doesn't work. It's just a thin layer of wood. If you have a plant touching it, every time the plant is wet, it makes the shingle wet, and in 2 years, 3 years, you have to replace all the shingles. That's what's gonna happen. So the only way to have a persistent, kind of permanent solution is to have a trellis maybe 6 inches away from the wall, something on which these climbing plants can go up. But that requires an agreement by the neighbor because the garage is on the property line. So I hope there is a way for the two neighbors to agree on that, remove some of the asphalt, put a trellis, and let climbing plants climb. Otherwise, I think it's just gonna be a consistent trying to plant something, watching it die, planting something new, and in 10 years, we'll have the same situation. So,
yeah, I remember this project now. I remember this by there, which I had in my yard, and you know, I'm sort of an amateur gardener by circumstance because I have a gardener, but you know, like most gardeners, kind of a blow and sweep kind of guy. And we were having varied success in our yard. And the thing about Carmel is it's a very challenging environment because it's basically cool and we have very alkaline soil. We really have very thin soils. So what I've discovered is you've got to fertilize regularly, like once a month. You really have to do that, and you need water. Now, there's a drip system there. I don't know if it's on a timer or not, but if it was on a timer where you have a deep watering cycle once a week, that means 20 minutes to a half hour you run your drip once a week. Usually that will provide adequate. Theoretically, that bougainvillea ought to do well there. That's a south-facing wall. It's warm. So that's the best opportunity you're gonna have in Carmel. any north-facing wall. Well, that has to do with local conditions, and if it isn't getting enough, direct sunlight on that wall, that south exposure to warm it up here in the day, bougainvillea is not gonna work. And it looks to me like that's, I think what I saw there was the plants are undernourished and, they're just not thriving. You know, they're alive, they're barely alive, but they're not thriving. So you need to go to a different species. And like I say, I'm just an amateur gardener. Basically, I try things, they die, I don't try it again. I get something else. I go down and talk to the guy at the nursery. And I found things that are working pretty good in my yard, so I stick with them. One of them is Lenten Rose. That stuff will grow anywhere in Carmel. It's got a beautiful little flower, comes back every year, but it doesn't climb up. This is not something that's gonna solve your problem. Although I think anything that was thriving along that wall would soften it, even if it wasn't particularly high. But long story short, I think we should stick with the original approval. It's incumbent upon the owner to make sure that those plants have what they need. I would recommend that he consult a nursery around here, and they'll give you some suggestions. It might take a little experimentation. Maybe you buy 2 different types of climbers, see which one does the best. But I know from experience, it's gotta be watered regularly, deep watering, it's gotta be fertilized regularly. And I know that the neighbor wants landscaping.
May I say
Yeah,
something?
come on up.
In regards to the shingle thing, these aren't natural shingles, okay? They're composite.
Oh, it's a composite
Yeah.
shingle?
Yeah. And nothing's gonna stick to them. And the second part is, there's a wire. Once it climbs that, it's gonna keep going. Also, Mr. Krugler, I think, has employed a full-time gardener. She's a nice lady, very knowledgeable. She comes every week to put his trash cans away. He doesn't want me to put them away, or my son anymore. So he has somebody that can do this,
Yeah,
okay?
well, sounds like he does.
And if the drip system, I don't know if it ever worked, but you could attach a fertilizing system to the same thing. On a timer, he doesn't, no mess, no fuss, the burden's off of him.
Yeah, there's a lot of ways to automate the water and the fertilizing. Okay, all right, thank you.
Okay.
All right, so,
Can I add something?
sure, come on up.
So, based on what was said and what Mr. Kovac wants, can we at least, move in that direction? And if we do everything exactly by the book, exactly like you guys are saying, if it fails and we come back, can we revisit another alternative?
Well, that's not part of our motion tonight, no.
No. I just want to, there's something to
Claudio,
think about.
something will work.
I would hope so, but
Yeah.
what I'm saying is, what if, because he did hire, I wasn't there, but from what I was told, professional, landscapers that know what they're doing, that they removed the soil and changed the soil and did all of that. Now, I wasn't there to see all of that, but that's my understanding. There were professional people who did that work. Now, all I'm saying is, if we try for a 3rd time, do we continue a 4th time and a 5th time?
I don't know, we need to.
I just want to put it out there.
We need to,
He needs to make it work.
All we're deciding tonight is that, it sounds like the way the commissioner's going, that the fence is not going to be acceptable.
Okay.
And it wasn't the original decision of the planning commission, and, the owner needs to take responsibility to find something to work. Now, there's ways to do it, and there's certainly plenty of knowledge about our local plants and what works in particular climates,
Right.
So we just have to work on it, but we may be talking to you again. If Mr. Kovac feels like you're not meeting the intent of the motion. And I would also hope that the neighbors don't turn this into a big thing. We don't need that. Let's just realize there's some challenges here. This is a challenging area to grow things. Everybody acknowledges that. And that we just, need to work on this together. And I think let's avoid this, you're on my property stuff. That doesn't solve anything, And I think Mr. Kovac pointed out correctly that this is so close, there's no way that you're gonna be able to not go on each other's property to solve this problem,
Definitely.
I share a fence with my neighbor. I let him know when I'm coming on, he says, fine,
Right.
do the work, but I always let him know.
Right.
And, you know, I just want to respect his property, but he's totally open to it when I go in his backyard, you know, work on the fence, because we've got this fence we share. And I think it's the same kind of situation here. I hope all neighbors do that. Let's just, you know, let's don't make the property line some kind of line in the sand that if you cross over that, oh my God, you've violated me. It's not about that. We're neighbors here, you know? We're all sharing this property, you know, this experience and living here together. Let's kind of promote that type of thing. So I just think that I would hope that you would send that message to the neighbor that he
Yeah,
needs
I'll
to
definitely
be,
talk to my
to be,
client,
you
sure.
know, and I know he's a part-time resident, but even as a part-time resident, he needs to keep in mind that, you know, we need to have a neighborly, cooperative attitude about stuff. And it takes a while to work things out. We understand that.
Chair, one final
Yes, go ahead.
comment. There is a recently planted, very narrow median garden, the Stillwell Hotel at Fifth and Mission, and it is on
Yes.
Mission on the
East side.
the east side of the street. It's rather narrow. I
With
know they
climbing
water.
vines,
There's like a
yes.
climbing fig, and then this other
Grass-like thing.
that I
So they have a similar
adore.
situation?
It's a
But
very
it's a
small,
similar, but
yeah.
it's a very similar, extremely narrow
Yeah.
patch of earth. They've been very successful, because that's only, what, maybe 2 years,
Yeah.
right? Yeah. And they've had quite a bit of growth. So just as a suggestion, you
No,
might
I
want
might
to.
take a look at it.
Climbing
You may
fig
want to
is-
have
I have
a
climbing fig on
peek.
my front yard fence. It's
So-
very
I'll
drought
pass it along.
tolerant,
Thank you.
and it grows pretty quickly.
Yeah, and this is in direct sunlight and same kind of
Right.
thing, so,
Yeah.
yeah.
So anyway,
Great, well, thank you.
I
Everybody,
think
thank
we,
you.
let us, why don't you guys sit down, let us finish this up so we can all go home.
So there's not what is the action that we are taking, because we're not making
We have
exceptions.
two resolutions, correct?
It was one resolution which you will not be adopting.
Right.
So you will be making a motion with direction to staff. I do have a question for the commission, though, if you'll entertain it. So in upholding the original condition, the condition does say, landscaping that grows or climbs at least halfway up the southern facing wall. I'm asking this for clarification on enforcement, as well as direction for the applicant. It doesn't specify that the planting needs to be located within the ground. Would planting within a container be acceptable? That way it doesn't need to be physically attached to the building. One concern that staff has, we were just discussing this and passing notes on it. Admittedly, I'm a bit embarrassed that it wasn't included in the staff report, we have forthcoming defensible space requirements. So attaching landscaping to a building might be problematic as we have those requirements coming down the road.
So I would recommend that we allow that because I live in an area where it's clay, right? And nothing grows. And so I've had great luck with bringing in, pots or raised beds or whatever. And I think that we should allow that.
And Mr. Kovac, I think you're nodding yes, that you would be agreeable to some kind of.
The space is like this.
Right, it's a very small space.
So you're gonna have to make it
But if you
bigger.
had a planter box that was maybe
Yeah,
just
if
a
you
little
had a nice
further out.
redwood planter box,
Okay.
a little taller,
Yeah.
it might encroach on my property, I don't care, okay? And then you could deal with this, right? Fresh soil.
Yeah.
I'm not opposed to that, but I'm not gonna come back here for a third time that he wants to try to extend this. Listen, I have a very sick wife at home. I'm tired of this, okay? I really am. I shouldn't even be here, okay? But just do what you said you were gonna do, that's all I'm asking. Enough said.
Okay.
Thank you.
Enough said.
I'm not in favor of a planter. I mean, why are we putting the planter there? Because of defensible space?
If for some reason it would need to be removed due to defensible space requirements,
Oh, it'd be easier to remove?
it's easier to remove, and then also if it could remain, you don't have, or a plant in in a container isn't necessarily a plant that would be a growing vine, so then you don't have it attached directly to the building. It could be a tree or a bush or a shrub, something that could be freestanding as opposed to directly attached to a building.
I think you're really, no. It's not gonna work. You can't, there's not, you're gonna have something that's gonna have to be a vine or it's gonna have to be a espalier. That's all there is to it. Now, the defensible space, that's another issue. If it comes up defensible space, we're gonna enforce that, you're just gonna have to cut it down. You're not gonna be able, you're not gonna be able to just take this planter and somehow move it away in time. I think it's just not.
I'm not suggesting it's planter, just a standalone, a series of pots.
There's no room for pots. There's less than a foot. That's how much space is there. Now, if Mr. Kovac wants to allow a cutout there and create some, but there's a drop off too. There's no flat spot. The flat spot that's there is what has been created. They've got a piece of a polyurethane or plastic binder board up against the asphalt. And then they've got the space is less than, I mean, if it's, you know, it looks to me like it's about 10 inches. That's it. So, and I think the wires are there. The plant is, you know, you need something that's gonna be a climber that's gonna grow onto the wires, you know. And you know, if we just stick with the original recommendation and let the owner get, you know, work on a plant that's gonna work and then provide the necessary care, I think that meets the original condition.
There's the post office has a climbing rose, been there for years. You can't kill the thing.
Roses are very hardy.
Yeah.
Very hardy. They
Just
really
get
are.
it established, and like I said, nature will take
And
its course.
I think it's a good strategy to train it onto the wires that I guess your son put those up or suggested they be put up. That's a good strategy. So you've got good infrastructure there. You just need to get some plants that are gonna work.
Oh, thank you. I'm gonna go
So,
home and have a shot of tequila. I hope you do the same.
All right, let's get on to a motion here. I don't know if I've even got the right motion up here. So the attachment number 1, resolution, that is to amend, right?
You are not,
This
you
would
are
be
not taking
denying-
action on attachment 1.
Yes, would be denying the request.
You're denying the request.
Yes. I
For
move
the
we
fence.
deny the request.
We're denying the request for the fence.
Correct.
I
Okay, and I'm
second
gonna
the
make the motion that we
Go for it.
accept resolution number 1, to deny the fence.
No, we're just denying the request.
We're just denying the request, sir.
Deny the request.
You're-
Deny the request for the amendment, correct?
Correct.
Yes.
Correct. And
So the-
staff will
and-
prepare a resolution for denial.
So, yeah, the original condition stands.
Yes.
Correct.
Okay, all right. I'll make a motion that
We already did.
It's all done, sir. Just call it, just do a roll call.
Roll call.
Roll call.
Commissioner Allborn?
Yes.
Commissioner Allen?
Yes.
Commissioner Karapekov?
Yes.
Commissioner Locke?
Yes.
And Chair LePage?
Yes, thank you. The motion is carried. Okay, that concludes the public hearing. All we have is the director's report.
I don't really have a report, but what are you guys doing next week?
What?
What are you guys doing next week? You want to hang out again? On the 18th? Okay. It's a date. That's all
We
I
want to give
have.
you all the time you need. That's it? Okay. All right, we're adjourned. Thank you.
I don't know. That kind of does sound good.